p.m. Clerk Keneally, would you please call the case?
Yes, Chief Justice Yance. It's the matter of Committee for Public Counsel Services and another, the Chief Justice of the Trial Court and others. SJC-12926.
Before we begin, could we have a roll call of all those who are present? First, with respect to the justices of the court, Chief Justice Ralph Vance should go by seniority.
Justice Frank Casiano.
Justice David Lowy.
Justice Kimberly Budd.
Justice Elspeth Seifer.
Justice Scott Casper.
And I will note that Justice Lang recused from this case. Could those representing Maxwell, CPCS, ACLU identify themselves?
This is Rebecca Jacobstein for CPCS.
This is Benjamin Keehn, also for CPCS.
Good morning, Your Honors. This is Matthew Siegel for the Massachusetts Association of Criminal Defense Lawyers.
Good morning, Your Honor. This is Jessie Rossman on behalf of Haskell.
On behalf of the Attorney General.
Good morning. This is Eric Haskell, Assistant Attorney General. With me on the line are my colleagues David Kravitz and Mindy Klenoff.
On behalf of the trial court and the probation service.
This is Daniel Sullivan on behalf of the Chief Justice of the trial court.
And do we have anybody from probation? Is Sarah Joss with us?
Yeah, I'm speaking for probation as well, Your Honor.
You are, okay. On behalf of the Department of Corrections and the Parole Board.
Charles Anderson, Department of Correction.
On behalf of the DA of Suffolk County.
This is Donna Patalano, General Counsel for District Attorney Rachael Rollins, and with me on the phone is Liz Riley, Deputy Chief of our District and Community Court.
On behalf of the District Attorneys for Berkshire, Middle District, and Northwest.
Good morning, Your Honor. This is Thomas Ralph on behalf of those districts. With me on the phone is District Attorney Marion Ryan.
Good morning, Your Honor.
On behalf of Bristol County and the remaining DAs.
Good morning, Your Honor. James Sullivan from the Worcester County District Attorney's Office. And with me on the line is Elizabeth Dumpsey Farris, Legal Counsel in the Hampden County District Attorney's Office.
And on behalf of the Sheriff.
Good morning, Justice. On behalf of the 14 sheriffs, it's Robert Hanez. Along with the line with me is Attorney Dan Baer.
I believe we had Sheriff Tusion. Is he also on the line?
Yes, Chief Justice. Peter Katujian with our Executive Director, Carrie Hill, on the line. I chimed in before you did, Bob. Thank you.
Is there anybody else who is on the line who has not identified themselves?
Good morning,
Your Honor.
Third District Attorney Andrea Herring.
And on behalf of the Special Master?
On behalf of the Special Master, Your Honor, this is Robert Jones from Ropes and Gray, and with me is my partner, Joshua Levy.
Good morning, Your Honor.
Good morning. Is there anybody else who has not yet identified themselves?
Yes, good morning. This is Gloriann Moroney, Chair of the Parole Board, and I am on the line to assist Attorney Anderson with any questions.
Good morning, Your Honor. Sarah Josh.
I'm sorry?
Appearing for the latter.
And David Rangiv is here appearing in the related case as well.
Right. Well, we'll do that one. That's Christie case. We'll do that case after we complete this one. So, in fact, we'll probably take a break to finish this case before we commence that case. Okay, we are here with a rather extraordinary hearing in an extraordinary time. This is the first telephonic argument, to my knowledge, that the SJC has ever conducted. And my 11 years on the court, it's the first time that I recall having a case in which we have 9 parties arguing. There are cases to be heard today, CPCS versus the trial of Massachusetts, and after a break, we'll hear the case of Chris versus Commonwealth. As you have been informed, although we generally live stream cases in ordinary times, this case will not live streamed. A tape recording of the telephone call will be made available only within 1 hour after the conclusion of our hearing in the Christie versus Commonwealth case. I know that there has been some discussion with regard to that, so let me help with gaining some perspective. Worked for many years, as you know, during ordinary videotape and provides live video and audio of all of our arguments, and they are available through live streaming. In order to maintain the audio quality of this particular argument and preserve it to be heard, we have come to the conclusion that we are unable to live stream it, and therefore will make it available as soon as practicable after the hearing. I will note that the Supreme Court of the United States, even in ordinary times, does not live stream or provide audio-visual of their particular hearings. In fact, even in ordinary times, on the afternoon of each argument, the court will post a transcript of that day's arguments, and an audio of the week's arguments becomes available only on the Friday of each argument week. So we'll be providing an audio well before what the United States Supreme Court does, even during ordinary times. And I will also note that the United States Supreme Court is not hearing arguments. They have postponed arguments indefinitely as a result of the pandemic. Before we begin to commence the arguments, I want to first make a number of thank yous, and then I also want to provide the protocol for the argument. My first thank you goes to Special Master Brian O'Connor and to his colleagues at Ropes and Gray, not only his partners and associates, but also the staff who assisted them, who have served pro bono in the role of Special Master and have worked tirelessly over the course of the last few days. As you know, Special Master O'Connor has submitted a report and recommendation, which was received by me at roughly 10 p.m. last night. It has been furnished to all of you, I believe, very early this morning, and I know that that is a short time frame for all of us to digest the report, but it is what we're dealing with. So I thank him and all of his colleagues for their extraordinary work and their very thoughtful work product. I also want to thank all of the attorneys in this case and all of those involved with the attorneys for submitting superb briefs and supporting affidavits in a very short time frame. I know that you have worked very, very hard and very diligently in providing us with briefing, which will greatly assist us in reaching this decision. So I thank all of you for giving up your nights and your weekends and working in extraordinary fashion to address the matters in this extraordinary case. And last but certainly not least, I also want to thank our clerk, Fran Keneally, who has been nothing short of heroic in attempting to arrange for the logistics of this argument. So I thank him and his staff for all of the work that they have done. We all know that all of you have operated in a very short time frame. This case was filed on March 24th. It is now March 31st. That means everything that has been done within the last 7 days. The time frame of the argument has been shaped by the exigency of the situation which we all face, and I think perhaps there's no better way to reflect the importance of having this matter resolved as quickly as is practicable by the fact that the number of individuals in Massachusetts who have tested positive for COVID-19 has increased by 500% since the date of filing in this case. Let me discuss now the protocol that we will maintain in view of having this to be a telephonic hearing. Each party who will argue will have roughly 3 minutes to argue without interruption of questions. If you wish to invite questions before then, you certainly may do so. You certainly simply say, Your Honor, I now welcome your questions, and we will then commence them. If you go beyond 3 minutes, you may in fact find yourself getting a question before too long has has passed. So we'll give you a certain amount of time to be able to present your arguments before we commence questioning, and I recognize that some of you only have 5 minutes, so you should think carefully as to whether you want to use most of that time to present argument or to answer questions, and I leave that to you. I ask that for those who are not speaking that you put your phone on mute so as to avoid any background noise that may interfere with the quality of us to hear and for the public to hear the recording once it is made public. If you are not using a cell phone, I ask you to silence the cell phone so that we don't have the ringing of cell phones during the course of this argument. When the questioning of the justices commences, the questioning will commence by seniority. That is, since Justice Lenk is recused from this matter, Justice Gaziano is the senior justice, and he will question first. When he has finished his questioning, Justice Lowy, then Justice Budd, then Justice Cipher, then Justice Kafker, and then I will be the last person to ask questions. When I have concluded my questioning, I will then give each of the justices, again by seniority, an opportunity to ask follow-up questions, and when those questions are done, the time will end. I will serve as the timekeeper with regard to this. We have explored the possibility of a 1-minute buzzer, but it's not likely to work. So I will seek to give people a 1-minute warning, but as with all arguments, the time will not end until the justices have completed any and all of their questioning. Now, this is hard, I think you all understand, hard for us to be doing this way. I think we can anticipate that there will be some glitches. I ask that all of you have some degree of forbearance as we work through this, and that all of us keep our eyes on the prize, which is to get this thing right. So, with that protocol having been set, I will turn to the first attorney who will argue on behalf of Macdel, and I'll turn to Mr. Siegel, and you have 15 minutes.
Thank you, Mr. Chief Justice, and may it please the Court. This case presents this Court, the parties, and the Special Master with an opportunity to save the lives of incarcerated people who are especially vulnerable to the coronavirus pandemic, and in doing so, to save the lives of many others. 3 principles should guide the Court's decisions about whether and how to use its superintendent's powers to achieve that goal. First, time and consistency are critical, so it is important for the Court to act swiftly, preferably today, to initiate a uniform remedy for the entire Commonwealth. A good remedy today will save more lives than a somewhat better remedy implemented and initiated on Friday. Second, the remedy should be initiated but not fossilized. We don't know what news will arrive in 2 hours, let alone 2 days. So any remedy...
Now joining, name not recorded.
So any remedy should be subject to constant reevaluation and readjustment. And third, it is important to grapple with the reality that a remedy will not release adequate numbers of people, and thus will not save lives if it is drawn so narrowly that the defendants eligible for the remedy are those who would never have been locked up in the first place. So those are the 3 points: speed, evolution, and meaningful relief to save lives of people in the Commonwealth. And with that, I welcome the Court's questions.
Justice Gaziano.
Okay. Good morning, Mr. Siegel. One question I have regarding the scope of your proposed order. On pages 16 and 26, you asked for the immediate release of all pretrial detainees age 60 or above. Back in 2009, there was a defendant by the name of Edward Corliss who was in the Superior Court in Boston, age 61 or 2, who killed a store clerk in Jamaica Plain. Mr. Corliss had been released on parole for a second-degree murder when he killed another store clerk in 1971. If we rule your way, a defendant like Edwin Corliss in as well untold numbers of child rapists would be released immediately. Does that case illustrate the danger of this categorical approach versus an individualized approach in assessment?
Good morning, Justice Cassiano. We take the point, and for that reason, we have worked over the weekend with the special master and acknowledged in our reply brief filed yesterday that we welcome an approach that would permit individualized review and objection by prosecutors to the release of any particular individual, and we are open to particular categories of people who would presumably not be released at all pursuant to this process. There is now before you a report and recommendation that we just think swings the pendulum too far in the direction of keeping people inside and therefore not taking enough releases to really curb this pandemic.
And I'm very curious about that. Siegel, what parts of it you know as far as the categories of crime, in your opinion?
I would point to three things, Your Honor. Yep. The first is that the categories are very broad, so broad, in fact, that even people who are held on bails after being deemed not dangerous enough to be held under 58A would still be ineligible under certain provisions for presumption in favor of relief. There's also the carve-out for people under Chapter 140, Section 121. So that's one category. A second piece of the report and recommendation that gives us concern is the 5-year look back, which says that if someone would otherwise be presumptively released under this arrangement, they would not be released if, let's say, 4 years ago they were serving a sentence for a drug crime. And the final thing I would point out is the overall issue of bail. Right now, there are people being held on bails in the Commonwealth who are in three circumstances that were unanticipated at the time the bail was imposed. The first is that their pre-trial detention could now subject them to a deadly disease. The second is that every bail in Massachusetts is now harder to afford because we are experiencing massive joblessness. And the third is that pre-trial detention is now indefinite detention because trials cannot be scheduled. So those are the kinds of issues we have. But again, we initiated this case a week ago, which, as the Chief Justice pointed out, is like a year ago now, to propose a remedy. But we have worked significantly with the parties and the special master to allow for individualized review in every case. Every case, Your Honor.
Thank you, Mr. Siegel.
Any further questions?
No, thank you.
Justice Lowy.
Good morning, Mr. Siegel. The first thing I'd like to say is that this master's report is really quite a document in such a short amount of time, actually in any amount of time. But I do want to ask you about the categories for pre-release that start on page 3, and there's 5 categories of pre-release. I'd like to focus on the third category because as I understand these categories of pre-release, they're not cumulative. If somebody is eligible under any of them, then they're entitled to the presumption. And as it relates to anybody who's not entitled to the presumption, it doesn't mean they're not entitled to an individual hearing. But the category that would allow anybody on a bail of $5,000 or less, if they haven't been determined dangerous under 58A. The concern with that category I'd ask you to speak to is that sometimes the district attorneys, for strategic reasons or resource reasons, don't request a 58A, and in good faith do not request a bail for preventative detention purposes, but they believe the bails that's necessary to reasonably assure the appearance of the individual is the best way to approach the case. And in the category that's going to allow anybody with a bail of $5,000 or less, subject to the conditions, one of which you mentioned, the 5-year look back, should that fall, all those individuals should have a right to an individual hearing. My concern is whether or not that category that focuses on that there was no 58A, should every one of those cases be entitled to the presumption suggested by the master?
Good morning, Justice Lowy. If I understand the court's question correctly, I think I have two responses. The first of which is an explanation, and the second of which is sort of a confession. The explanation is that we don't think that this is categorical release in any case as currently constructed. It's a tipping of the scales that would otherwise be favoring detention right now in favor of release.
I appreciate that.
Right. And we assume that in any case in which any of the conditions that you mentioned, Your Honor, apply, a district attorney would do a very good job of pointing that out to the court and would may likely prevail. But the second thing, and here's the confession, I mean, we're all flying blind here. We don't know what the situation is going to be in the side prisons and jails soon, and none of us, despite best efforts, know really how many people are going to be released pursuant to this process or any other process. And that's why what I said in my second point at the outset is it's really crucial that this be reevaluated. If this is implemented today and we get the list back and it's too many people, people are getting out, being suggested for release who are inappropriate candidates, the district attorneys can raise that. If we get the list in 2 days or 3 days and there are only 5 people suggested for release, then we will know that that's not going to curb the pandemic. And so I acknowledge that I, like everyone else, don't exactly know what the outcome of this process is, which is why we think it ought to just be initiated, and then be subject to revision.
Thank you, Mr. Siegel.
Thank you, Your Honor.
Justice Scully, any further questions?
No, thank you, Chief Justice.
Justice Budd.
Hi, good morning, Mr. Siegel. I think I read in the Special Master's report that anyone seeking release would be tested. Is that right, for COVID-19?
Good morning, Your Honor. I'm not entirely sure I know. There is a provision in the report which seems to suggest that actual or presumptive cases would be subject to a different process and may be held back. I think one of the issues that we're dealing with right now, Your Honor, is that nobody knows what the testing protocol, if any, is inside prisons and jails.
Okay, so that's something we'd have to figure out. If somebody was presumptively positive for COVID-19, I think in the report it said there would be a review process for that. What is MACDO's recommendation for somebody who tests positive for COVID-19 but otherwise meets the whatever standard we decide is appropriate for release?
Your Honor, I want to acknowledge that's a very difficult question, and it relates also to questions concerning people who may experience homelessness if they are released. But what we have done is we have worked very hard with the Special Master to provide information about service providers who can place people in homes and who can make sure that medical needs, including a potential need to self-quarantine, can be met. And so we really think there should be an individualized review to determine, in the case of someone who might have the disease or experience homelessness, whether they can safely be placed somewhere. But we also think, Your Honor, that as a legal matter, the restrictions placed on such people should mirror those that exist for people who are not incarcerated. For example, if I believe that I am sick right now, I may self-quarantine, but I'm not going to be locked in a prison. And so if someone is wrapping up a sentence or entitled to relief under this provision, or under a court's ruling, they shouldn't be locked up because they have been diagnosed or presumptively diagnosed with an illness.
Well, I don't disagree with that, but I guess I'm wondering, how do we make sure that the virus isn't spread as a result of the release? And obviously that's a concern as well.
I don't disagree, Your Honor, and so that's why I think I would go back to the point about working with social services in conjunction with a special master to make sure this happens, which is what is happening right now in the settlement that was reached in New Jersey. But also, this is why, I mean, it's such a difficult problem that's why I keep emphasizing that getting the process underway is so important, because however many people are going to be in that difficult situation, it's going to be more tomorrow and the next day and the next day than it is right now.
Thanks very much.
Justice Seifer.
Thank you, and good morning, Attorney Siegel. Most of my questions have been answered. I just want to clarify and make sure I understand your position now in light of the Special Master's report. Is it fair to say that in general you're looking at a categorical approach that then turns into an individualized approach and re-entry services or needs would be addressed?
Good morning, Your Honor. I think that is mostly fair to say. I mean, the where we start from at MACDL is the need to effect releases in sufficient numbers to make a difference to the folks who are released and to the folks who remain inside and to the community. So honestly, if it were sort of like what this court did in the Hint Lab scandal and just achieve a certain number of releases, there would be a pretty good argument for prosecutors to have much control over all of those. But another approach which we are okay with is the Special Master's approach, which says, let us create a presumption for certain categories subject to what we assume will be a very rigorous objection in some cases by those on the law enforcement side. And I also just want to say, partly as a response to the last question, this is not a situation in which this disease exists only in the prisons and jails. It's already in the community as well. So what we're trying to do is to avoid a situation where we overwhelm the resources, the healthcare resources of the Commonwealth, and that's why it's really about the numbers. I mean, everyone talks about flattening the curves, and that's why we need a remedy that achieves certain numbers of releases, and why it would need to be reevaluated very quickly, let's say twice a week, if it does not.
Okay, thank you.
Justice Kafker.
Mr. Siegel, I really appreciate your point that we need to move extremely quickly, and we can't try to get the perfect document right here. My question is, it's a follow-up to Justice Gaziano's. I've just read the Special Master's report like you quickly this morning, but it seems like a carefully calibrated and balanced attempt, to deal with both the risk to the inmates and the detainees and the risk to the public of releasing people who've been accused or committed crimes. I'm trying to refine what you want us to improve in. I know you don't like the 5-year look-back provision. Do you have, for example, alternative language that you would put there? I didn't quite understand your point about bail, but I just, as specifically as possible, particularly if you would like us to get this out in the next day or two, how do we improve the Special Master's draft in a way that you think would make a better approach?
Good morning, Your Honor. I appreciate that question, and I think in the spirit of not letting the perfect be the enemy of, I don't know, a life raft,
right.
I would say this. The things that could be done quickly in the context of this document would be to excise the 5-year look back and to limit particularly the definition of excluded offenses, which sweeps in things like Section 121 and the like, and certain drug crimes, which are just going to, we have a concern that very few people will be eligible here, and those who would be eligible will be white. And I think another thing that could quickly be inserted, again in the spirit of, I think, of your question, would be to say that if there are counties where there can be agreements to go above and beyond what is required by the letter of this agreement, that should be pursued. If there is a district attorney who believes that it is necessary to save more people, that district attorney should be able to work out something with the petitioners.
Doesn't the document have a couple of those type of fail-safe or flexibility provisions in there? I know there are some that, no individual who's excluded from this, is precluded from seeking this type of review. I take it there's nothing that would prevent the DAs and defense counsel from, expediting this even faster than this is required, right?
Your Honor, I believe that's a perfectly accurate description of the existing document, and if the sentence you just spoke were to be added to it, I think it would be even better.
That's all.
Partly this is because, and I would just say, Your Honor, partly this is because part of the virtue of this document, at least as we understand it, is to make things more uniform throughout the entire state. Everyone's scrambling around, not knowing where to go for their hearings or how to set them up or what rules to invoke. And so setting the tone for the state, including what the procedures are, and that there need to be some releases, and that where there's agreement, it would be good to allow that to go forward, I think would go a long way.
Thank you. That's all I have.
Mr. Siegel, this is Chief Justice Gantz. We've been focusing to some extent in the questioning with regard to those who are detained awaiting trial, for whom clearly our superintendent's power would apply. Let me turn to those who've already been convicted and are serving sentences. I know that the master's recommendation suggests that we use our authority under Rule 29 for revise and revoke. To what extent would the exercise or the revision of our Rule 29 authority raise issues under Article 30?
Good morning, Mr. Chief Justice. We think that this is not at all the type of situation in which revising Rule 29 to address this particular crisis would create separation of powers problems. What we have proposed in the reply brief is slightly different, but I think consistent with the Special Master's report, where we think the rule could be revised to account for the current facts, to eliminate the timing deadline, and to make clear that the trial judge who could order relief under Rule 29 could include the single justice in this particular case, which would create more opportunities to speed relief to people. I would say, in addition to the authorities we cite at pages 22 and 23 of our reply brief on this point, I would also point, Your Honor, to Commonwealth against Rodriguez, which is at 461 Mass 256, where the court ruled in 2012 that the rule could be invoked even despite a plea agreement. And I think the reason why that's true and why revising the rule in this situation would not be problematic is really this. The concerns that can arise under our separation of powers are when the court is acting like a grantor of clemency or like a supervisor of the growth and parole eligibility of the defendant. That's not the situation here. This is more like a situation in which the sentence that a court imposed turns out to be through inadvertence, deadly inadvertence, not the one that it intended. It's like finding out that you've sentenced a prisoner to a prison where there is mustard gas floating through the facility, or where all the chairs are electrified. And the court says, I meant to sentence this person to one kind of sentence, but has turned out to be a potential death sentence, and I need to fix that. And that authority to fix sentences is squarely within the power of the judiciary.
Now, would your revise and revoke be a permanent change in sentence, or would it simply provide some sort of a stay?
Your Honor, to simply stay a sentence, the court would not even need to change Rule 29. It could simply invoke the powers described in Commonwealth against Charles, the Hinton Lab case about the stays of sentences that arose in that situation. But we do think that it would be appropriate here to allow not only for the stays of sentence, but for to revise and revoke them, and that would require a change probably to Rule 29. I'd also point out that here too there could be some opportunity to go beyond what is strictly required. In a situation in which people are going to be let out, whether on stays or revise and revocation, we're talking about people who are going to go and resume their lives. We don't know how long this pandemic will last. And so we will encounter situations in the future in which people may have to be pulled away from jobs and family to serve a sentence that the prosecutor themselves might feel doesn't need to be sorted out, it doesn't need to be finished. And so there should be some opportunity, we think, for prosecutors and defendants to reach time-served pleas at the end of this process, however long it lasts. But the short answer to your question, Your Honor, I think, is that stays can be done as a matter of case law, and shortening sentences could be done as a matter of amending Rule 29.
And with regard to stays, those are generally stays pending appeal. Would it be your view that they would apply to individuals who do not have pending appeals or motions for new trial?
I think that the rule could be revised, Your Honor, even in the absence of a pending motion. And that is one reason why we think that the trial judge, for purposes of the revised rule, could be the single justice. It should be possible to streamline this process. And as we said in our reply brief, and as Your Honor pointed out in the remarks you gave at the beginning of this argument today, the normal procedures make a lot of sense under normal times, but the problem right now is that those normal procedures are just not fast enough to be meaningful for the people who are locked up.
I have no further questions. Justice Gaziano, any further questions you might have?
No, thank you, Chief.
Justice Lowy?
No, thank you, Chief.
Justice Budd?
All set.
Justice Cipher?
No, thank you.
Justice Kafker?
All set.
All right, Mr. Siegel, thank you. Ms. Jacobstein?
Good morning, Your Honor. Rebecca Jacobstein for CPCS. I just want to let this court know about the things that CPCS is doing to help with this process, because we're ready to go. We are working to get our teams together for the review process in every county. We have our SSAs, our social service advocates, have been working very hard to gather all the information for all the people who are going to need help if they are permitted to go back home. We've got substance abuse and mental health, and these are things that we set people up with, as a matter of course, and we will continue to and, redouble our efforts. And we have also been working to find places for people to go who may not otherwise have places to go. I also wanted to address the court's questions briefly about about the excluded offenses, because I think it swallows the document. I don't think there are that many people who will be eligible. If they were, that's great. Then we have no objection. The goal here is to get out as many people as quickly as possible, so that the people who remain can practice social distancing and keep safe. That's the goal. And however this court wants to get there quickly, we are in favor of. So, but we think that the excluded offenses are going to hinder that. So, options we have foreseen as kind of the biggest obstacle, is the residual clause, which has been deemed unconstitutional, but that exists, and also the force clause under 58A. The fighting over what counts as something under the residual clause or under the force clause is just going to gum up the works. And for people who are, again, in on offenses that could have raised 58A, but they didn't, I think that speaks to it already. We think all firearms offenses is overbroad. That it covers improper storage, it covers possession of a firearm without an FID card, and these don't even have mandatory minimums. And motor vehicle homicides, which have terrible outcomes, are where people are often killed by accident. So it's not that, it's just not the same thing. So those things we think could come out. But I realize that time is of the essence here, so I would like to if anyone has any questions.
Okay, Justice Galgiano.
Good morning. Let me ask you a mechanical question, because as I went through the very well-written master's report, as you say, the exemptions are very dense, and it takes you a while to get through them. And say we pare that back or do something else with it. What I wonder is the inception of this process, where you laudably have your committees ready to go. Could it be, or would it be more expedient if you get a list from the jail and or the DAs that say, here are all the people in a particular county that are held pending trial, and then CPCS can get that list, and either they represent the people or someone, usually because they're indigent, someone under their auspices represents a person, then the defendants file that motion, and we have expedited hearings in the Superior Court or District Courts of BMC. I'm just wondering if we need the first step to be so complicated, if it would be quicker to do it that way.
Your Honor, I think that this would have been a fantastic process if we had started it like 2 weeks ago. Because if we had the names of all the people in the jail, unfortunately we at CPCS are not able to track every single person that's still incarcerated.
Right.
Then this is something we would do. But now it's too late. I can tell you that people in our office, and I've been hearing from bar advocates as well, statewide are encountering difficulties getting heard. I heard from someone who sent theirs in last Thursday, finally figured out how to get a clerk to do something with it, and their hearing is scheduled for next week.
Right. What I'm envisioning, though, is if we order these hearings to be expedited, say, within 48 hours. So you file the motion, right? So you have your listserv, you file the motion, you have a form that I'm sure you fill in the blank. You put the person's name, Joe Jones's name on it, and it gets filed in the relevant court through order. We have expedited hearings.
I just
wonder if that's quicker than this other process.
It's not. I mean, first of all, we have 7 district attorneys who are objecting to this entire thing. So I can't imagine that they're going to agree with anything, which means without a presumption, we're going to have a lot of hearings with very few judicial resources. So that's the first thing. I think that without guidance, we're also having disparate outcomes across the state. And that is why we did originally ask for all of this to go through the single justice, because what we're seeing in some courts is awesome, and what we're seeing in other courts is really discouraging. Where agreed upon releases are being denied. So, I hear you and I understand, and I think 2 weeks ago that would have been great. I just don't see us being able to do it. However, let me say that it would be great if we did get the list of people who are in the jails.
That's the first step, I assume.
Right. Well, so I think the first step in the special master's report is they'll get the
right. I'm just wondering about that. I'm just wondering about the lag time and whether that's going to cause too much delay in and of itself. And how practical it is to go through the jail list and try to correlate that with the exemptions. I don't know how that can be done in 48 hours.
Well, I think, Your Honor, I mean, I can't speak to it because I haven't seen the jail list. I don't know how many people are in their pretrial. But I'm guessing, having seen jail lists in the past and what they have, I think it's probably going to be very easy once you take out everyone who's got these excluded offenses to see that there's pretty much nobody eligible left. So whoever is left, I think we should be able to find them relatively quickly. But also I do think that part of the problem is because things like the force clause and the residual clause are in there now, and also the 5-year look back, you got to pull everybody's, incarcerated. You somehow have to look at their CORI and figure out when they were last incarcerated. I mean, it's logistically very, very difficult. And if we could simultaneously have a jail list and bring people to the DA's attention, that would be fantastic.
No further questions, Chief.
Justice Louie.
Yes, Ms. Jacobstein, good morning. I'd like to follow up on Chief Justice Gantz's questions about revise and revoke, and assuming, I'm not sure the assumption is correct, but assuming that the 60 days could be extended within a superintendent's power, what about the issue of considering post-sentencing circumstances? We talk in terms of post-sentencing conduct in the revise and revoke cases. Where do you see this circumstance that we're in now as it relates to the doctrine applicable to revise and revoke, and following up on the Chief's question, where that line is as it relates to separation of powers?
Well, I think that, sentencing is always with the court. So, I think that if, and we don't review sentences for reasons of finality. But Your Honor did point out that this isn't conduct. This is more akin to the cases where, for instance, somebody else got sentenced and then the court said, well, my sentence isn't fair in light of that, but that doesn't change, that isn't a new conduct or, since sentencing. So, and I don't really see the separation of powers issues where the sentencing is in the hands of the court, and also where the court is in charge of the rules and, can make temporary rules, like, for instance, this court did in the Gomez case.
Great. Thank you.
Justice Bud.
I'm all set. I don't have any questions for Attorney Jacobstein. Thank you.
Justice Cipher.
I don't have any questions either. Thank you, Attorney Jacobstein.
Justice Kafker.
Attorney Jacobstein, I'm still, again, trying to be as specific as possible, particularly because I share Mr. Siegel's concerns. We have to do something fast and get it started. So you identified a couple of excluded offenses that you don't like: the gun offense, gun possession, but some driving offenses. But as specifically as possible, if we're going to do this today, what do we change?
I think that you take the subclause 4 of 140 section 121 out, otherwise involves conduct that presents a serious risk of physical injury to another. Just cross that out. I think that's one thing you can do, no problem. Then under 58A, you take out a felony offense that has as an element the offense, the use, attempted use, or threatened use of physical force, because again, it's too hard. It's just too hard. We fight about that all the time, and that's too hard. We'd also ask, so that's one under A, so 58A, A1, and then also 5.
Okay, sorry, go ahead. Go ahead, and then I'll ask.
Okay, so 5, which is an offense for which a mandatory minimum term of 3 years or more is prescribed in the Controlled Substances Act, so we'd ask that come out. And then again, the homicide or manslaughter by motor vehicle. So those are things that I think we could quickly do. And then there's a sub 7 just sitting there. That's any felony offense, again, that has an element of use, threatened use of physical force.
The other thing I'm confused by is your desire to shift this to the single justice, realistically, there are only 5 of us who are on the phone who can be single justices. I may have misunderstood what you were saying, but you don't want to really turn this over to the 5 of us as single justices, as opposed to drawing on all the resources of the trial courts, do you?
I think so. When we just have, the theory is that if we have a bunch of agreements, we just want to get that through the single justice, because then it's faster. I think that for disagreements, because originally the way we had, before the framework, that's how we envisioned it. But where there's disagreements, that should go back to trial judges, because they make those decisions.
So you want a process in which agreements between the DAs and the defense counsel can immediately go up to the single justice for approval. So you don't think the existing order provides for that?
Right. I guess that we have just, in some of our courts, it's been struggling, and some of our courts are closed, and you all are definitely open for business. So, that's really the concern, is that we get email addresses and people don't check them. People don't know how to check them. Courts are closed. Somebody gets sick, and it's in such flux. The single justice session is there, and it's ready to go. And so that's for agreements. We feel like it would be faster.
Okay, that's all I have. Thank you.
I've got a few questions of logistics. So, if John Smith has a particular counsel, what would be the role of that particular counsel in all this? How do we work so that certain individuals are designated to serve as counsel for John Smith, even though that was not his attorney during the course of the case?
So I think we've got the pretrial people and the post-conviction people. So the pretrial people, I think the goal is to get their attorney right on that. But if their attorney is unable to get on that because of the pandemic, then we will have another representative of the defense bar. We are putting together teams, not just, the representative, but teams of people who are going to be ready to contact the jails, talk to the clients, get the information that they need, make sure that they have the supports that they need so that we can do this. But that's the plan, is to have, a kind of core of attorneys for pretrial people if they're not available. In post-conviction, if they have an attorney still, we may give it to them, or we may just keep that with our, core of people.
And if individuals are privately retained and are not indigent, how would it work?
I guess we'd have to give them a call. We do provide most of the criminal defense attorneys in the state, so I just don't know how many there are. I can't speak to that. I think we take at least 80% of the cases. And I don't know what the percentage is for people who actually go to jail.
I guess if they're being represented by CPCS, it's pursuant to an appointment by CPCS. So I guess arguably CPCS could revise the appointment for those for whom counsel may be unavailable to address this matter. Okay. Do you see a difference, by the way, between those who are awaiting trial in Superior Court as opposed to District Court versus the BMC?
No. I mean, they're more likely to be held on what is currently an excluded offense.
Okay. I have no further questions. Justice Gaziano, any further questions of you?
No, thank you, Chief.
Justice Lowy?
No, thank you, Chief.
Justice Budd?
No, thanks.
Justice Cipher?
No, thank you.
Justice Kafker?
No, thank you.
All right. Thank you, Ms. Jacobstein.
Thank you, Your Honor.
Now we'll hear from Mr. Haskell on behalf of the Attorney General.
Good morning, Your Honors, and may it please the Court. I'd like to begin our remarks today with three observations that informed my office's approach to this issue over the past 7 to 10 days. The first is a widespread recognition, borne out by common sense, and I hope, widely shared, that prisons and jails present very unique challenges when it comes to managing the risk of this disease that call for some sort of expedient action. The second observation is that this space around incarcerated persons who are there because of a judicial order stands at the intersection of certainly two and really all three branches of government, and that is a dynamic that needs to be acknowledged and respected with respect to any solution here. And then my third observation is to refer the Court to the 6 broad principles that were the centerpiece of the brief that we filed very early Saturday morning, to the effect that any relief this Court gives needs to be mindful of promoting the public health not only within prisons and institutions, but also of the public generally in this time, that the public safety and the rights of victims need to be borne in mind at all times, that any relief ought to provide the opportunity for individual case-by-case review, and finally, that any relief this Court orders ought to be temporary, commensurate to the nature of the problem. That is to say, where the disease presents a temporary problem that someday is going to be resolved, this Court should be ordering relief of a similarly temporary nature. My office played an active role in working with the other parties and the petitioners collaboratively and frankly tirelessly over the past couple of days to craft the report and recommendations that the Court has in front of it. And our view is that the report and recommendation appropriately takes account of all of those considerations that I just described, and for that reason, our office stands by the report and recommendation and likewise recommends it to this Court. With that, I would welcome questions.
Justice Graziano.
So I take it, Mr. Haskell, by your agreement with the report, that you also agree that releasing incarcerated people under revised Rule 29 would not violate Article 30?
That's right, Your Honor, and the best articulation of this space that I found, and of course my work on this case, was given by this Court in the Sheehan case almost 100 years ago in the 1920s, where the division of power is described as the legislature setting penalties for crimes, the judiciary imposing sentence, and the executive branch actually administering and executing that sentence. That's a big part of the reason, Your Honor, why the report and recommendation was focused on the act of sentencing, which is within the province of the judiciary.
Did you find any significance in the fact that Rule 29 specifically says a judge may not take into account conduct of a defendant that occurs subsequent to sentencing because of those very issues of executive function?
Well, Your Honor, you're right. That is the typical rule.
And that's the reason why Rule 29 has that provision.
Well, certainly Rule 29 sets up a system that discourages the judiciary from intruding on the prerogative of the executive in this sense. What strikes me about the law around Rule 29 here is that it speaks more to the defendant's the convicted defendant's post-sentencing conduct. What we're dealing with here is a circumstance that may have existed as some remote hypothetical possibility at the time a sentence was passed down, but now is real and represents a global change of circumstances that it really is nobody's fault.
So this circumstance existed when someone was sentenced 5 years ago?
Your Honor, the possibility of an exigency like this, I think, always existed, but was never really top of mind until the past couple of months. Now that it is, I think it loops back to the language that Rule 29 uses in describing unjust sentences, which goes to whether justice has been done through the sentence. Through the lens of what's happening right now, we believe that's an appropriate consideration with respect to revising and revoking a sentence.
Thank you, Mr. Haskell. No further questions, Chief.
Thank you, Your Honor.
Justice Lowy.
Yes. Good morning, Mr. Haskell. Ms. Jacobstein mentioned the issue of some agreed-upon recommendations to the court that a pretrial detainee be released are not being adopted by the court. And, of course, each individual judge will make his or her own decision. Would it be helpful, nonetheless, to include that within this presumption of release?
I'm sorry, Your Honor, to include what?
The agreed upon recommendation that a pretrial detainee be released.
So first of all, as to instances of this happening, I have to say, having spent a lot of time with these issues in the past week, I'm not aware of that, and I would direct the Court's attention to the affidavits that we submitted by the Chief Justice of each of the trial court departments, as well as the affidavits that were attached to the 7 DA's memo, in which representatives of the various DA's offices, present facts about what's going on in their counties. Our sense is that the trial courts right now are really doing their level best to address issues that are placed before them on an emergency basis. That having been said, Your Honor, to answer the remaining portion of your question, our view is that the trial judiciary has a role to play in the solution here, and has a very important role to play, such that it would be inappropriate to ask the trial judiciary to rubber stamp something, even that's been agreed, and that information to allow the trial judiciary to make an informed choice in each case where there's going to be a dispute or some opposition is appropriate and is correct.
So I assume then that you would be opposed to the agreements going straight to the single justice based on your answer?
Our view, again, Your Honor, is that the trial court is really in a good place to help be part of the solution here. As was noted earlier, the single justice has limited resources. There's only a handful of you, frankly. The trial courts have better access to the files, in some ways better lines of communication to the DA's offices and the defense bars. So yes, that is our view, Your Honor.
Okay, thank you.
Thank you.
Justice Bud.
Hi, good morning. Just going back to the question about testing, has anybody looked into whether that's something that can be done before people are released? And I understand we're all struggling here, but from everything I've seen and heard and read, testing is important to sort of contain this. And so, has anybody given any thought to whether there'd be some sort of testing protocol to make sure that people are free of the virus and not going out to spread the virus? You know, they may be asymptomatic and that type of thing. So I'm just wondering if that's been given any thought to.
Yes, it certainly has been, Your Honor, and as you know from the report and recommendation document, there's actually a provision in there. It is on page 6, going into page 7, about how those who are positive or presumptively positive for the disease ought not be released. I think your question also loops back to one of the principles that we articulate and stand on in our brief, which is that any release ought to do more good than harm to the health of the general public. And I think those two considerations go hand in hand. So if a trial judge, as part of any release, were to order, or if a district attorney's office were to insist on in connection with any release, that somebody who's going to be released be tested, especially in a situation where, for instance, there are already instances of the disease within the walls of that particular institution, I think the report and recommendation gives room for that, and that would absolutely be an appropriate consideration.
That's not exactly what I'm talking about, because I'm talking about asymptomatic transmission. So this is when people are walking around not realizing that they could be spreading the virus. You know, any one of us could be spreading the virus, right? Anybody who we release could end up spreading the virus without even realizing it, without having symptoms. And so I guess I'm asking if there is a way to incorporate a protocol for testing people who are released. It doesn't appear that that's been contemplated, but I'm wondering if it's something that should be.
I think I understand your question and your concern, Your Honor, and as to whether testing has been baked into the report and recommendation, basically as a precondition of anybody's release, you're correct that it's not required right now. Whether it would be appropriate or feasible, I think would depend on a lot of considerations, including the availability of the medical equipment to achieve that, which I'm afraid I can't speak to.
Okay. And can you also just respond to Attorney Jacobstein's argument or concern about parties getting tied up in the force clause of 58A and so on?
Yes. Your Honor, the force clause of 58A, as well as the force clause of Chapter 140, Section 121, which also appears in the excluded offenses, in our view, is a key provision of the definition of excluded offenses. As we argue in our brief, any releases that are achieved through the relief that this court orders ought to be protective of the public safety, and the presence of those provisions within the definition of excluded offenses, in our view, is very important to help safeguard the public safety. Certainly, there may be some questions around the margins about whether a particular crime of conviction falls within those definitions, but our view is that the report and recommendation brings enough people to the table and calls for enough resources and attention to be devoted to this all-hands-on-deck effort that's being contemplated, that those instances can be identified and sorted through in prompt order.
Okay, thank you.
Thank you.
Mr. Seifer.
Thank you. I want to go back for a minute to the position that Mackle and the CPCS have taken and see what your position is with regard to these excluded categories in the document by the special master. Do you agree that they swallow the document? They really create too much of a block to what we're trying to accomplish?
We do not, Your Honor. I'm sorry, go ahead.
No, so if you don't, then do you have a subset that you could carve out of that would make it easier?
I'm afraid we don't, Your Honor. The entire report and recommendation, including the list of excluded offenses, was the product of a long, hard, drawn-out, and very constructive conversation over the past several days. We are comfortable that the existing proposed list of excluded offenses strikes the right balance between all of the different interests that we describe in our brief that we believe this court ought to be mindful of.
Okay. Two more questions. One about the whether it's a single justice or the trial court. Are you saying that you think even if there is an agreement between the DA and the defense attorney that it should still go to the trial court and couldn't or shouldn't just come to the single justice?
Right now, the report and recommendation does have those going to the trial court and specifically carves out a role for the trial court to play there before the trial court is asked to order those releases. As to whether those kinds of proposed releases ought to go to the single justice instead, I think the considerations there would have to do with resources on the county court's side and whether that's something that the county court feels itself well positioned to get involved with, and also the possibility of creating different processes for different categories, I wonder whether that would create more confusion than order. Also mindful that under the existing report and recommendation, the single justice does have a role to play in adjudicating summary type appeals from decisions made by the trial court, and so those are the considerations that I would suggest the court think about in connection with that question.
Okay, thank you. And you contemplate when it goes in front of a trial judge, even if it is agreed upon, that the trial judge would be checking to make sure that there are adequate services or places for the people to live.
Yes, going back to the principle that we describe in our brief about releases ultimately serving the general public health. Yes,
okay,
that's appropriate.
Now, bearing in mind that the public safety, as you say, that everything should take into account the general public health, what's your position on this presumption of release?
So the report and recommendation does call for a presumption of release with respect to the pretrial detainees that are described in the document. We feel that that's appropriate for two reasons. First, the category of pretrial detainees that are beneficiaries of that presumption of release has been very carefully defined and demarcated going back to the list of excluded offenses, among other considerations. And we feel that the definitions around who's eligible and who receives that presumption is part of what makes the presumption appropriate. The second thing that in our view makes that presumption appropriate is the opportunity for the prosecutor to object and for the trial court judiciary to exercise independent judgment, again, consistent with the principles discussed in our brief about how rather than blanket or categorical relief, relief ought to be as best as possible made on a case-by-case basis.
Okay, thank you. One more final question, Chief, before I say thank you, is that you might not be the right person to ask this of, but do you have any updated statistics on the number of people incarcerated, either as pretrial detainees or as prisoners who are serving a sentence who have tested positive or have exhibited symptoms?
Oh, on that point specifically, I'm afraid I don't. Best I can offer on that is the information in the Commissioner of Corrections affidavit that we submitted.
Okay. I'll wait till we hear from the Commissioner. Thank you.
Thank you, Your Honor.
I'm all set.
Justice Kafker.
So I'd like to follow up on the Chief's questions to defense counsel on the constitutionality of this for a second. Because, I mean, Rule 29 seems like, I mean, it's creative, but it seems like an odd fit here. Because are we really revising and revoking these sentences? You know, they were correct at the time. We've just got this new public safety emergency. I mean, you've done a lot of research on this. Is there any case law dealing with this kind of emergency? It seems it's more like jail overcrowding than revise and revoke. But tell me why you believe this is constitutional for incarcerated as opposed to pretrial detainees.
So, Your Honor, I think that goes back to the remarks that I made earlier in response to Justice Gaziano's question about the Sheehan case and the tripartite division of responsibility between the three branches of government in this space. What the judiciary has the authority to do, and the role that the judiciary plays, is to pass down a sentence. And part of the reason that we focused on Rule 29 as a vehicle for relief here is it's something that is, in our view, pretty solidly within the judiciary's lane, so to speak. And
but we don't revise and revoke. I mean, just Justice Gaziano's point about conduct. We don't take into account later conduct. Do we take into account later events? In the jail overcrowding cases, we have usually a finding of unconstitutionality, right? A cruel or unusual punishment finding. I take it you're not saying we need to make that finding here to act, right?
That's right, Your Honor. And the way way the case, I'm sorry, go ahead, please. I'm sorry.
No, and I don't mean to cut you. I'm just struggling myself with the constitutional justification for people who were given correct sentences at the time, but we have this public health threat. And I would add another factor. I don't find deliberate indifference here based on the submissions that we've been presented. So I'm trying to get the constitutional basis for this, because these are properly sentenced people, and there's nothing at the time that indicated the sentence was incorrect. It's this subsequent temporary development. Is there any case like this out there? You say Sheehan. I got to look at Sheehan again, but is that the best case for us for this?
And Sheehan, Your Honor, Sheehan, we like, and I've cited the principle that's articulated by Sheehan. I'm not sure that the court will find the facts particularly illuminating of Sheehan.
Right. So are there any cases,
Your Honor?
Are there any cases like this? I mean, where we've been given an ability to temporarily suspend sentences, as opposed to the executive branch exercising its powers to furlough or, something else. It would be nice if there was some better precedent than this. There may not be, but I'm just trying to understand what's out there.
I'm afraid this is thin gruel, Your Honor, but we don't have a precedent to offer on that. What we would suggest is that Rule 29 and the provisions of Rule 29 and the function that the judiciary plays pursuant to Rule 29 are things that are within the province of the judiciary, and that's the reason that we focus on them. These are extraordinary circumstances. They've come up in an extraordinary way that I don't think anybody could have predicted or anticipated. And, Your Honor, we think it's fair to think of these circumstances as affecting whether justice has been done, which is what Rule 29 speaks to in subsection A2. And that's part of the reason that we feel Rule 29 is an appropriate vehicle for potential relief here.
Did you also consider, Mr. Siegel talks about maybe it was in response to a question, that a stay would not even, that this is more like a stay of execution and it wouldn't require, that's more within our power even on a post-sentencing, post-appeal. Did you look into a stay as a better vehicle or an alternative vehicle and reject it as opposed to this Rule 29?
Well, and I should also say, I'm sorry, Your Honor, I should have mentioned this a moment ago, that we do agree with you about the lack of a constitutional basis for relief here, and I think we mentioned as much in our brief. Okay. As to a stay, the report and recommendation actually contemplates that in it's on page 8, Roman numeral 3, paragraph 4, in speaking about what a trial judge who's entertaining one of these emergency special Rule 29 motions is able to do. I think the idea there, appropriately, is that the trial judge would have discretion to fashion relief, but the report and recommendation in that paragraph, paragraph 4 on page 8, specifically speaks about staying an inmate's sentence until after the emergency is over, and also speaks a bit about what is to happen to the sentence after the emergency is over, again, consistent with the principle we discuss in our brief about the temporary nature of relief to deal with a temporary emergency.
And my last question, and I know it's difficult, who's the AG representing in this case? Just remind me.
Your Honor, I understand. The Attorney General at this argument is speaking for herself. She's representing herself and her office. At the time that we filed our brief early Saturday morning, we did file it on behalf not only of ourselves, but also the trial court, or excuse me, the Chief Justice, the Department of Correction, and the Parole Board.
And are all those people still in the fold, or some outside the fold now?
Your Honor, they've chosen to appear separately at the argument, and perhaps any more about their position, questions would be best directed to them.
Thank you. That's all I have.
Thank you, Your Honor.
This is Chief Justice Gantz. Mr. Haskell, let's assume that the special master's recommendations are followed and that all act in good faith. What would you estimate to be the reduction in the jail population resulting from the exercise of that authority?
Your Honor, I'm afraid I'm not able to answer that question for two reasons. First, I don't have that data. That has not come across my desk in the past week. And second, as the Court well knows, the process that the Special Master's report and recommendation would set in motion is going to depend on decisions that are to be made by other parties, including the prosecutors and the trial judiciary. What I will say is that the report and recommendation specifically includes a provision for the Special Master to weigh in on how the process is working. I believe the Special Master is required to do that in pretty short order, within 1 week of the report and recommendation going into effect. And our hope and expectation is that review process would present an opportunity to talk through and hopefully to achieve any modifications that might be appropriate.
Well, let me come at it a different way. What percentage reduction, or either based on a design rate capacity or other measures of how crowded a jail or prison is, would accomplish a material change in the public health risk to prisoners and to prison or jail staff?
Again, Your Honor, I'm sorry to have to say this, but that's not something that I'm able to offer an answer to, in part because it's going to depend institution to institution and what the circumstances are there. It's not like we have expert reports of epidemiologists or public health professionals outside of the affidavit of the Deputy Secretary that we put in. And, Your Honor, any relief that's ordered here, as we describe in our brief, ought to balance a number of different considerations that are sometimes in tension with one another. And in our view, the appropriate way to approach this is in a way that balances all those considerations rather than focusing specifically on one of them.
Right. Well, I'll ask it another way, and I guess we'll be hearing from both the sheriffs and from DOC on this issue, but how little is too little? I mean, the process basically permits the capacity to evaluate to what extent it has had consequence. Do we have any measure of magnitude as to the extent of reduction that needs to be accomplished to maintain the public health goals that are being argued here?
Well, Your Honor, one of the things that the report and recommendation calls for all the way at the very end is reporting and the involvement of public health experts in connection with evaluating those reports. And in our view, that is the appropriate vehicle for assessing those concerns and for providing an answer to that question. I'm afraid it's not the kind of thing that anybody, and certainly not I, could offer an answer to at this time and place.
So Ms. Jacobstein says, if we were to include the excluded offenses as provided for, it will mean that very few individuals are not going to be excluded. Let's assume that she's right for the moment. Would that cause you to reevaluate whether or not we should change the category of exclusions?
I think, Your Honor, that is a bridge to be crossed when we get there, consistent with the reporting and reevaluation provisions of the report and recommendation. But Your Honor, I think what my office would be looking to if, say, 7 days from now we find that this protocol has had no meaningful effect, I think what my office would be looking for is a recalibration that serves the same 6 principles that we've described in our brief and that I keep referring back to, because the goal here is to achieve an appropriate balance that serves all of those things.
Do we have the luxury of that time? The governor says that the peak danger period is going to be, I believe, April 7th to 17th, and that's a week away.
Your Honor, we've emphasized consistently through our briefing and our argument that it's important to act promptly here in response to an exigency, but it's also important to act thoughtfully here in a way that takes account of many different considerations. Our view is that the master's report and recommendation, developed as it was through a series of very deep and involved conversations with the various parties and stakeholders, achieves an appropriate balance, at least for the first go-around.
Okay, I've got no further questions. Justice Gaziano, any further questions that you may have?
No further questions. Thank you, Chief.
Justice Louie?
Yes, I do. Thank you, Chief. Mr. Haskell, one thing that seems to be missing in our discussion today, and I wonder if we could say something to make it part of the equation, is that as it relates to pretrial detainees, this document is simply outlining a presumption. And then the master puts in a comment that I think is very important, that if an individual doesn't fall within the presumption, that's not a factor that the judge should consider in any other request for relief. Do you think there's something that we could do to emphasize that point? If you are not within the presumption, that in no way impacts the judge's decision for all other individuals. It's just that there is no presumption. Do you think we need to do a better job at making sure that point is understood?
So, Your Honor, what your question's getting to is the kind of emergency motions for release and relief that incarcerated folks have been filing for the past couple weeks, and that, as described in the 4 Chief Justices' affidavits, the trial courts are handling currently right now. Our view is that the report and recommendation doesn't and should not have any impact on that process, that the notion that a presumption or a lack of a presumption should have no impact on an individual detainee's motion for relief or for release. And if that's a point that the court chooses to amplify in what it does with the report and recommendation, I think that's a very fair point.
Okay, thank you.
Thank you.
Justice Bugg.
Actually, I do have a question. Just given, considering the questions that have been raised about the constitutionality of what's being requested, is there any role here for the governor and his office taking action here?
Your Honor, as we've said, this space sits at the intersection of at least 2 and probably 3 branches of government. Because this whole case is arising in the form of a case, of a litigated judicial case, where this court would be the one to order relief, we focused on mechanisms of relief that are within this court's province and within this court's authority to order. There may be things that can be done by other parties, but I'm afraid I might not be the correct person to speak to those things.
Okay, thank you.
Justice Cipher.
Thank you.
I have no further questions. Thank you.
Justice Kafker.
One last question. The mandatory minimums, I take it, are outside of our province, right? That if a sentence has a mandatory minimum, can we do anything without intruding on the legislature's prerogative, constitutional right there?
That is our view, Your Honor, and that's one among several reasons why mandatory minimums were carved out of the report and recommendation.
Okay, that's all I have. Thank you.
I have no further questions. Thank you, Mr. Haskell.
Thank you, Your Honor.
Mr. Sullivan, on behalf of the trial court and probation.
Good morning, Your Honors. This is Stan Sullivan. I may please the court. I wanted to say, first of all, that we were participants in the brief submitted by the Attorney General, as witnessed by the fact that there were 4 Chief Justices and also the Commissioner of Probation who submitted affidavits that were part of that brief. Where we part company with the Attorney General is with respect to the recommendation and report. I just wanted to make a brief opening statement, and then I'll get to some specifics on that. So I'm appearing today not only for the Chief Justice of the trial court, but also for the Chief Justices of the Superior District and Juvenile Courts and the Boston Municipal Court. I've communicated with them in detail and at length about this proposed order, and their principled objections to the proposed order have been sustained and emphatic. The Chief Justices understand that this is an emergency, and they understand the concern for the welfare of the inmates. However, in one crisis after another, whether war, disease, or natural disaster, or any other disruption, America's and the Commonwealth's social and public welfare have been anchored and sustained by committed adherence to the rule of law and to fundamental due process. In support of those principles, I assert the critical need to maintain the central role of the trial judge in adhering to tested rules of procedure and legal process, not only to protect the rights of criminal defendants, but also to ensure the rule of law is upheld. The Chief Justices recognize urgently the need for all deliberate expedition in addressing the motions for relief by inmates who are more susceptible to this lethal virus than others. The trial court is committed to devoting whatever judicial and personnel resources it must to ensuring that these inmates' motions are heard promptly. The Chief Justice has all assured me that this is already happening. These matters are currently being heard, often within 24 hours of being filed. Turning to specifics, the first thing I wanted to address was the presumption. We disagree with this presumption, and we had proposed to the special master that rather than it being a presumption that it be whether or not a person is eligible to be released. One of the problems
now joining.
One of the problems of this is that it takes away the trial judge's discretion. In many of these cases, it would be a bail redetermination, and in those cases, the judge who granted bail has already been subject to a presumption of recognizance, and that presumption was overcome for the person who had been committed. And now we're imposing yet another presumption on the judge reviewing this motion. So we believe that the court should put its confidence in the trial court judges to make those determinations. Another point I wanted to make was this is on section 2C3B, which is on page 5. This refers to releases agreed upon group of inmates. This suggests a group motion for the primary trial judge to rule on with a short statement in support of the entire group. The judges need to act on individual motions, and they've been emphatic about this. Moving on behalf of a group of detainees is exactly the kind of shortcut that will lead to inadvertently releasing a person who is more than capable of committing violent crime. Inmates are individuals. They're not fungible. The fact that an inmate suffers from diabetes does not mean that he is any less capable of committing crimes than an inmate without diabetes. The other point I want to make is with respect to the amount of bail, the idea of anyone under $5,000 in bail. The justices all noted that is a very high amount. They said that there are many dangerous criminals who were committed based on a bail amount that high. And then the other point I wanted to make was on page 5 of the document, section 2C4. There's a reference there that within 5 calendar days of the entry of this order, the primary trial court judge will convene an expedited short-form video or telephonic conference. And the justices asked repeatedly what is meant by that. The idea that they would be subject to some limitation on a hearing. These judges are not, the judges will have no interest in extending these hearings or elaborating them unnecessarily. And it just wasn't at all clear to them. We raised this with the special master as to what was meant by a short form hearing. Ordinarily, the judge will hear what he needs to hear in order to make a determination. And then just one quick point on the review, the appellate review. There's no standard provided as to what will be the case that will be heard on appeal.
Okay, Justice Graziano.
Good morning, Ms. Sullivan. With respect to the beginning, I'm going to ask you the same question I asked counsel for CPCS. As far as that process as contemplated by the special master's report, how cumbersome or unwieldy would the trial judge find that, and are we better served by expedited motion practice like we're used to?
That's been very much the view of the Chief Justices, that they believe that there should be motions. They understand that these will have to be on an expedited basis, but they believe there should be motions. One of the things that was mentioned was at some point this crisis will have passed, and it may be necessary to reconstruct the reasons that a judge ruled as he did on such a motion. This is the kind of shortcutting that seems to concern them most. Judges are concerned that if someone is released and commits a heinous crime, it won't go back to the DA or it won't go back to the members of the committee. It will come back to the trial judge, and the question will be, what did you know about this person when you released him, Judge? What did you have before you? And so for that reason, the judges very much want to have complete information on people. Now, we worked with the special master, and in footnote 4 of his report, he identifies some things that should go in that file. One of the things, though, that I mentioned that was not included in that file was a requirement of a plan of release. And this is very important, and probation is very strong on this as well, that it can't be the language that the special master added to try to deal with that said that the judge should have any available material on a plan of release. That's not sufficient. The judges need to have a clear picture of where this person is going. It's been often the experience that someone believes a friend or a relative is willing to take him or her in, and in the event that doesn't occur, and particularly now where these people may be concerned the person being released may be contagious. So I think it's absolutely important that a judge be able to see a plan of release and know this person's not going to be released to roam the streets.
Now exiting.
Jane Sullivan.
Potentially lapsing into addiction or committing further crimes.
Thank you, Ms. Sullivan. No further questions, Chief.
Justice Louie.
Mr. Sullivan, good morning. You make some very important points. I just want to pick up on the presumption issue. It is true that every judge who has ruled on a bail that's not under 58A has dealt with the presumption of recognizance, and if they've imposed a bail, made a determination that the presumption's been rebutted. But cannot the judge entertain that you have changed circumstances and the document does not dictate a decision before the trial judge? Rather, it seems to create another presumption based on the obvious changed circumstances. Do you think that's really a deep concern, nonetheless, to the trial judges?
I believe it is, Your Honor, and we're not saying that that's not a consideration that the judge would take into account. I'm sure the judges will, but the idea that the judge should be able to make an independent judgment, he should be able to exercise his or her discretion without being burdened by, as I say, a second presumption on top of the presumption of recognizance.
Of course, but every time a judge imposes a bail, that judge has taken into account the presumption, but has had no difficulty doing his or her job and finding that despite the presumption, a bail is going to be imposed. I guess because I'm really concerned about all the points you've made. They're very important for us to take into account. Very important. But I don't see where this presumption that's sort of infused into the master's report and recommendation to take into account changed circumstances in any way handcuffs the judge's enormous discretion.
Well, I think it's probably just an additional pressure point for the judge to contend with in what's already a very difficult decision. The idea, I think, is that why would these individuals...
Now joining, name not recorded.
Excuse me, why would these individuals be presumed to be releasable? As I say, the fact that someone has an underlying health condition doesn't make him necessarily any less likely to reoffend. They feel this, running through many of the things I've said, and this has been a theme with the Chief Justices, is that judicial discretion is being impaired. And what they've said is, if the court elects to would elect to take away our judicial discretion in making these decisions, the court should issue its own order authorizing the release of anyone in these categories who's not subject to more than $5,000 bail. And the idea there is really that the judges see their role as making these determinations, and they want to make them on a case-by-case basis with all the necessary information so that they will feel confident in releasing the person.
Thank you, Mr. Sullivan.
Thank you, Your Honor.
Justice Budd.
Hi. Can you just give us a sense of how things are working now? You're advocating for a case-by-case presentation without any presumptions on any categories of inmates. So can you just give us a sense of how it's working now? And I'd like to hear about Superior Court and the various district courts and BMC.
Well, what the Chief Justices of both the district and the Superior Court have told me is that these motions are being promptly heard. That there hasn't been a wait for someone to be heard. The judges understand this is an emergency and that these are emergency motions. So they have been hearing them. And I don't think it's accurate that there's been delay. As far as I know, in the hearing of any of these motions, I heard of one motion in Superior Court in a Western County where it was the judge said he wanted to await the determination of this court based on this hearing. But as far as I understand, he was instructed that he should rule on the pending motion. We want to get through these, and that's really the goal, and that's why I say, Justice Budd, that we will really devote whatever resources are necessary to doing that. And we recognize, we're not expecting people to draft elaborate motions. I understand that the motions may be almost a template where they cite the grounds for release. But at the same time, as I mentioned earlier, the judges very much want to be able to look at a record and to know who the person is, what his history is, even what his behavior has been while imprisoned. They don't feel comfortable signing release orders without having that level of knowledge.
Do you have any statistics on how many petitions or hearings that have been requested so far?
I don't. I know there was some of that material, Your Honor, in the affidavits that were submitted with the brief in which we joined with the Attorney General. That's the best that we have to date. Is to the extent that we were able to, some of the Chief Justices were able to give those numbers. I know, for example, the Juvenile Court Chief Justice was very specific about the numbers, and I think the District Court did a pretty good job on that as well.
Okay. And then, is there any part of the Special Master's recommendation that the trial judges feel like might not be a bad idea?
Well, to the extent that it's constitutional, and I defer to the court on that, the idea of using a modified version of Rule 29, I think struck the justices as not an inappropriate approach. So I think that, I'm assuming that rule could be modified even on a temporary basis. And I wonder if that really wouldn't be an approach that could even be applied. I would think it'd be an approach that could be applied broadly.
Okay, thank you so much.
Thank you, Your Honor.
Justice Kafker.
Hey.
Oh, Justice Pfeiffer, I'm sorry.
You're bumping me for Kafker again.
I'm sorry.
Jeez. Mr. Sullivan, can you tell me, I understand you don't have any record of anybody not being able to get a hearing or anything like that, or hearing about that, but that would be, by its nature, something you would not necessarily hear about. So what steps can the trial court take to address the specific concerns of CPCS and Haskell about this difficulty they perceive in getting hearings sometimes? Is there a central location you can set up for them to make a request or a complaint?
Well, I think in terms of handling the volume, that I wouldn't want the judicial resources devoted to this to be restricted. In fact, Chief Justice Dawley had said to me that he thought that there should be a designated judge in each district court to handle these petitions. So that's really where they. And I should say, in terms of saying there haven't been any motions delayed, I know that I believe that Chief Justice Dawley and one of the other Chief Justices have both been in touch with the leadership at CPCS and have said to them, look, we understand this is an emergency. If you find people are being delayed, you let us know. And at the point when those questions were asked, at least, the leadership said, no, as far as we know right now, we're in good shape. So, but I do think that this is something that will require a tremendous amount of judicial resources, and the judges are all ready. Obviously, these hearings would have to be telephonic like this one, but I think that all hands will be on deck, Your Honor, in terms of getting these matters heard. As I say, I think it's going to be an expedited process, but I think it needs to be a process.
Okay, thank you. One more question, and that is going back to this idea of a presumption. You're suggesting that first you deem somebody to be eligible rather than determine that they are presumptively eligible? Is that correct?
That's correct. That had been our recommendation. The special master actually adopted that, and then as a consequence of pushback, I believe he went back to the presumption. But and I understand that, and I should say, the special master and his colleagues have done a masterful job of handling all the contending parties here. But that we do feel strongly that presumption that the person should be released puts an undue burden upon the judge's discretion.
And then, so if we don't have a presumption to start with that a certain categories are presumed to be releasable, you would say let the trial court determine whether they are in that category of releasable, and then from there determine whether in fact they should be released. Is that correct?
Well, yeah. I would think based on the work of the committees that an individual would be determined to be eligible to be released. But then the judge needs to look at the specifics of the case. He needs to look at and we would have, and we propose this basically a uniform file that would be put together that would include, the carry and various other, the police reports, the underlying complaint, for example, any critical documents, as I mentioned, a plan for the person's living conditions after he or she is released. So with that packet, I think a judge would be able to rule. There was one other point I wanted to make, that there was a suggestion that someone could be, about people being released without a hearing. And I think it's critical that if a judge is going to apply new conditions to an individual. If someone had already been on probation and had conditions set, those would remain in place. But if a judge believed it was necessary to set new conditions, I would think the judge would need to have a hearing. So I didn't like the idea of saying that the district attorney will make a determination and then the judge should just grant this without a hearing. I think a judge should determine whether or not a hearing is called for in any given case.
And so if the parties were in agreement, if CPCS and the DAs were in agreement on a particular case, you see a role for the trial judge to still conduct an active hearing.
Well, he wouldn't necessarily conduct a hearing. I think in many instances, Your Honor, these matters will be decided by a judge on this kind of basic file that would have to be provided in each case. But my point was that if a judge, in his discretion, says, I need to hear something on this. There's something in the file that catches his eyes. I want to hear more about that. I think that there shouldn't be a case where a judge is told, you have to decide on the papers and you can't schedule a hearing irrespective of what you may think.
Okay. Thank you.
Thank you.
Now, Justice Kafker.
So I understand, and totally respect that the chiefs are working tirelessly and all the judges as well to expedite these proceedings, and that seems to be supported by the affidavits we have here. But I guess consistency is one of the issues that we're dealing with here. I take it your clients want nothing to be done differently than what they're doing right now. Is that correct? You want us to basically do none of this order, right?
Well, no, I don't think that's accurate. I mean, as I say, we're talking about a specific file that would be provided. These matters would be heard on an expedited basis. We don't disagree with the idea that things have to be done quickly. What the disagreement, I think, is the idea that the judges should be ruling on group motions. That judges should be required to presume that the person is releasable. That in any other way, a judge's discretion should be infringed, because that discretion has served us well for many hundreds of years, and we believe that that's an important principle of our system of justice, and that's really where I think the Chief Justices come down.
But I'm confused though. So I understand. I just want to make again. I'm caught up in practical realities and specifics. So the judges now are, in your view, are expediting all of these hearings, doing everything humanly possible. They're also doing them often by video conference or telephonically. Is that correct?
My understanding is that to the extent that they're hearing matters now, that I believe that in most instances they're being heard telephonically.
I'm trying to understand what's different. I understand you don't like this presumption, which doesn't seem, by the way, very difficult to rebut. You seem to have a problem with page 5, paragraph 4, that this expedited hearing, but aren't we conducting these expedited hearings? I just don't. What's the difference between what's being proposed in paragraph 4 than from what is actually happening? And I want you to, I know you're upset by this, but I want you to be specific to what is that you're doing differently than what they're requiring here or proposing here.
With respect to the conduct of the hearing, I think probably very, very little is being done any differently. I had raised the issue of what's a short form hearing. I mean, don't be interfering with the judge's discretion, but I think that this is precisely what these judges are doing right now.
Okay, so then let me go back to paragraph 4, the paragraph about the presumption for a second, because as Justice Lowy pointed out to you, we've got a presumption of recognizance anyway. We also have, a dramatically new fact, which is we've got a dangerous situation in the jails because of the coronavirus. So again, how how much different in the real world is this proposal than what is actually being done here? And does it just provide a focal point? If we change the word presumption that these people shall be, given high priority, I'm just trying to understand, we need some consistency and some urgency. And again, I'm not exactly sure what's bothering you besides removing some perception of discretion. So articulate specifically the practical impediments for judges, because I don't want to get in the way of trial judges doing their job correctly here. But I also don't want to turn sort of word phrases into obstacles when they don't change what they're actually doing.
I think, I mentioned a couple things. This idea of group motions is anathema.
Where in the order are we talking about group motions?
Hang on one sec. Sorry. This is on page 5 at lowercase b. With respect to any inmates for whom the parties agree release is appropriate in a specific county, the parties shall provide the judge with a short statement in support of the release of the agreed-upon group of inmates. The trial judge shall expeditiously act on the recommendation without further hearing. So again, both those, group of inmates and without further hearing, both of those things, we believe that these matters should be heard or ruled upon, in many cases on the papers, individually, and we don't think the judge should be constrained from conducting a hearing if he or she determines that a hearing is necessary.
Wait, did you read the last clause?
Yeah, no, that's right. So that part of it's okay.
So, but that means the primary trial court judge can individualize every single one of those if he or she wants, right?
Well, I was concerned about the language of a group hearing.
Okay, all right. You don't like that.
A group motion, I should say, Your Honor.
Other specifics that are going to fundamentally or significantly change what the trial judges are doing right now?
I know, to be honest with you, I know that on the red line that we submitted of the previous version of this order, we had many comments and proposed revisions, many of which weren't adopted. But I think those are the critical points, Your Honor.
Okay. Sorry, what's the critical point? What is the critical point?
Well, I think the idea that this process will interfere in some way with the judge's exercise of his discretion, or that a judge will be required to rule without adequate information, without hearing what he needs to hear. So that's, I mean, I think that's really, they came back again and again to the impairment of discretion. Now, you know, there may be ways in which it's impaired that I haven't described, but that seems to be the concern, and I've tried to identify the ones where it that they've pointed to as indicating some constraint upon their discretion.
Thank you, Mr. Sullivan. That's all I have, Chief.
Thank you, Your Honor.
Mr. Sullivan, this is Chief Justice Gantz. Certainly I understand the extent to which both the trial court chiefs and each of the judges and the clerks have been trying during these challenging times to accomplish as much justice as is possible. But I want to, and I certainly understand the idea that a judge wants to make sure that before he or she makes a decision that the person has the information before him or her to make sure it's the correct decision. But I want to make sure that I flesh out some of the thoughts that you presented. You spoke about the standard being eligibility for release, but can't any person who is on bail seek bail reconsideration based on changed circumstances? Isn't every person eligible for release?
Right, but I think that the idea there, Your Honor, is that we're saying that the conditions that have been described, the person is over 60, the person has an underlying health condition, and so forth, that those are things that would make the person deemed, if you will, eligible to be released. Obviously,
any person may move to reconsider bail, especially with a change in circumstances. Don't you agree?
Well, perhaps there's a different way to describe that. I know the objection was to a presumption. They're more than happy, and they I think daily now consider all the factors that are raised by the crisis. But they seem to feel that when this came particularly from the Chief Justice of the District Court, that this was an impairment of their discretion, that the judge was going to be making a decision that could have very serious consequences down the road, and that the judge should be, he should be relied upon, his judgment, or her judgment should be relied upon without burdening it with a presumption in one way or another.
All right, well, let's flesh that out. I mean, you agree that the bail decision itself is considerably constrained by both statutory conditions and conditions established under our case law, correct?
Right.
I mean, the presumption of release is statutory. A judge is obligated to consider ability to pay. That's constitutional. There are a number of things which a judge's so-called discretion is limited because the judge has to apply certain standards, both constitutional, statutory, and based in case law, correct?
Right.
So help me to understand the concern about the loss of discretion. Would you consider it to be appropriate for a judge or within a judge's appropriate discretion to say, I don't care about the pandemic. I think it is an irrelevant consideration, and it does not bear, and it does not constitute a change in circumstances which should even be considered.
No, I wouldn't.
Okay, so
and I'm confident that the judges would not.
What standard should you say we should apply to provide guidance to a judge if that would be an inappropriate exercise of discretion?
But these are critical factors to be considered. And that's why I say that they need all the necessary information. I think this all goes into the calculus, Your Honor. But that's really something for the judge to sort through, as they do, as you say, on bail determinations generally.
Okay. Well, I'm trying to understand how different it would be for us to say these are, quote, critical factors, unquote, as opposed to, under certain circumstances, this is a presumption which can be rebutted based on other circumstances. What is the practical difference between those two?
Well, the notion is that it in a way suggests a thumb on the scale, Your Honor. That they should be able to make these decisions without any pressure one way or another, based on the facts before them.
But you just said that. I mean, is it unfair pressure to say that these are critical factors?
No, I don't believe so. I think that the change in language may be sufficient. What I think was balked at was the idea of a presumption.
Okay. Now, in terms of, would it not be? I mean, in most, certainly in Superior Court, which of course I'm most familiar with, we have a first session where all matters would go to, and we have an efficient way to deal with a whole set of matters. Is there any
now exiting
Marion Ryan? Is there any concern in the trial court for having the equivalent, essentially, of a first session of a judge who's going to be assigned to address these matters?
No.
So it's okay to establish essentially the equivalent of a first session to say, the first session is here, we will handle these matters, we'll have a 10 o'clock teleconference, and we'll bring all these matters before the first session judge or the equivalent.
I haven't heard any objection to that kind of practice, Your Honor.
Okay, so you're not concerned then about the view that there should be certain designated judges, whether they be by county or by court. That's
now joining, name not recorded.
The idea of Yeah, I'm sorry. For those who are coming and going, it'd be easier if you'd leave the phone untouched as opposed to turning out and coming back in. But is there any concern about having there be designated judges, however we choose to designate them, so that they are available and can do this stuff in volume, as opposed to trying to go back and find the particular judge who may have set bail?
No, there's absolutely no objection to that, Your Honor.
Okay. So, and I assume that it would be beneficial to this first session judge to have the DA and defense counsel and at times the sheriff and probation confer beforehand and essentially identify those for whom there's no objection and those for which there would be objection.
Absolutely.
Okay, so that process is something which you say is a sensible process, is to attempt to vet these matters so that you can present matters and say, Your Honor, there are 3 matters or 5 matters before us. There's agreement as to 3 and there's disagreement as to 2.
I agree with that. I think that that goes back to the idea that I think the objection is to basically a non-judicial panel making a determination that creates a presumption, and so that's really, they're willing to, they want to look at each case.
Okay. Well, I mean, so certainly, I mean, in the scenario that I'm doing, whether you call it critical factors or call it a rebuttable presumption, the view was that the judge, of course, would be able to consider each case, and the court could say, I think that's a thoughtful agreement by counsel, and I agree with it, or could say, for whatever reason, I disagree with it. Correct?
That's correct, Your Honor.
They just want the capacity to make individualized decisions that are not dictated by others, but which they have the opportunity to consider.
That's correct, Your Honor.
Okay. And with regard to plan of release, isn't that something that you would want to be vetted ideally before you go before the so-called first session justice, so that the judge can say, what, do we know what's going to happen to Mr. Smith and his probation on board?
Right. Well, I mean, it's really as much probation as anyone else who've been emphatic about that, about not releasing people, onto the street who have nowhere to go. So that obviously probation would do what it could. I think the concern is that if this is, I know that when someone is in prison for a period of time, that there's a period of planning that occurs before that person is released, where they work with a counselor to determine where you're going to live, what's your form of transportation going to be. I think that the concern is that if this is pushed too quickly, that won't occur, and that probation won't have an opportunity to call the cousin whom the inmate says he could live with and find out if he's really wanted there. It's really just a question of the judge being able to know that the person has a place to go. It's not enough that he or she hopes to have a place to go.
Okay, but you also understand that everything we're doing as best we can under the circumstances.
No, I do, but I think that there's a real concern with just putting people on the street if that process is essentially eviscerated.
I understand. But your concern is the evisceration of it, not the expediting of it.
That's correct, Your Honor. Yeah, I'm sure. I think all of this will have to be expedited, and I think that the personnel, both of probation and I know this from the commissioner, stand ready to do all they can to expedite these matters.
Okay, and I guess with regard to the $5,000 bail, you said that that often is what dangerous criminals are being held for, but if they're being held on $5,000 bail, that means there was no dangerousness hearing held and no finding of dangerousness.
You're right, and there's a poor choice of word, because you're right. They do exclude the dangerousness, people who have been found to be dangerous, statutorily dangerous. I guess the idea there is what they said, that there are many people, anyone who's being held on that amount of bail, the judge would have had a reason, a serious reason, to set the bail that high, and they just thought the number was too high, Your Honor.
Okay. I've got no further questions. Justice Gaziano, any questions that you may have?
No, thank you, Chief.
Justice Lowy.
No, thank you, Chief.
Justice Budd.
No, thanks.
Justice Cipher.
No, I'm all set. Thank you.
Justice Kafker.
All set, thank you.
Okay, thank you, Mr. Sullivan. So,
Thank you very much, Your Honors.
we've been at this now for 2 hours. What I suggest is that nobody leave the phone, but I'll ask, I guess, my justices, is there any objection for us to take a 5-minute break? And it's 12:10.
Not at all.
And reconvene at 12:15, but please don't hang up. Don't want to have to create a phone call. Okay, so I ask all just to put your phones to the side, and come back 12:15, and at 15 we'll hear Mr. Anderson on behalf of our and the parole board. Okay?
Okay.
So, again, hang up.
That's good.
Don't hang up.
Okay.
See you here at 15. Thank you. Scott Baziano, are you there?
Yes, Chief.
Okay. Justice Lowy?
Yes.
Justice Budd?
I'm here.
Justice Cipher?
Yes.
Justice Kaff?
Yes.
Okay. Mr. Anderson, are you there?
I am, Your Honor.
Okay, you have the floor, sir.
Good afternoon. Charles Anderson on behalf of the Department of Correction and the Parole Board. I have 4 overall observations and 3 comments on the master's report specific to DOC. One thing that's been pretty clear on the record is that the Department of Correction has taken substantial steps to protect its inmates and will continue to do so. Both the Department and the Parole Board are committed to working within constitutional bounds and statutes to keep the inmate population as safe as possible. It's clear from the affidavit of Commissioner Michi that when the governor declared the state of emergency on March 10th, the department immediately implemented its epidemic control plans, these plans which were developed long before the scenarios we have today. And these plans are centered around isolating and containing those inmates who are affected by the coronavirus, as well as limiting the entry and screening all of those who enter Department of Correction facilities. Rather than rehashing everything that's in the affidavit, it's pretty clear that based on the record that the department's response to the pandemic has been informed, reasoned, responsive, and adaptive. And I think as Justice Kafker pointed out earlier, there's nothing on the record to show or demonstrate any constitutional basis of relief here because there's nothing on the record which shows that the department has been deliberately indifferent to a substantial risk of serious harm to its inmate population. In terms of where we are now, the department, as of Friday, the commissioner's affidavit stated that there were 10 inmates positive for COVID-19, all housed at the treatment center, and there were 13 that were under quarantine protocols at that time. The numbers have changed, so as of this morning, the department has 17 inmates that have tested positive for COVID-19, all at the treatment center, and all being housed in the same unit. I believe the 7 inmates to be diagnosed since Friday were part of that group that had been quarantined because they showed symptoms. So that's where the numbers are now. And I think one thing that has been referenced in the earlier discussions, and I think is important to state, is that the court, in crafting a remedy here, has to consider what could be substantial public health risk posed by the release of a wide class of inmates. And it has to consider it both on the macro level, considering what the risk to the public is, the potential additional burden that risk of large groups of inmates will have on an already overburdened public health system, and whatever public safety issues also would accompany the large release of inmates. Also on a micro level, on an individual level of release of inmates, any order has to consider that individual's access to support systems after their release from the department. Because what we have on the record is a lot of discussion about what the department has done, hasn't done, but there hasn't been a lot of discussion of what awaits anybody who is being released by these orders. And that's something that the court has to keep in mind, both to mitigate any risks to those inmates being released, as well as to the public health. And one thing I just wanted to add to that is in terms of the classes of inmates or the categories of sentenced inmates that the court is looking to initiate release protocols or orders on, the department begins its re-entry planning in earnest with inmates at the 1 year left to serve mark. As it's more detailed in the commissioner's affidavit, it's at that point where inmates meet with the re-entry specialist and they start to go over what their housing is going to be, what they need for identity documents, what their health care needs are and access to health insurance would be, employment plans, and community resources. And these meetings continue both at the 6-month, 3-month, 2-month, and 30-day mark. It's usually at the 30-day mark where inmates apply for mass health, 30 days before they're released. So one thing that has to be considered in all of this is not just what's going on now, but what the impact is on both the inmate and the public at large should inmates be released under this order. Another overarching comment I have that I'll address more when I talk about the master's report is the court must also be cognizant about its superintendent's authority and the issues of separation of powers. Most of the separation of powers issues have been brought up by others already in this proceeding, but I do want to bring up one in the context of talking about the master's report. There are 3 comments that I have with regard to the master's report, all it's section 3, I think in like the paragraph 4 mark. The first comment is any order for release of an inmate from department custody has to be accompanied by a stay of sentence, a revocation of sentence, or sentence deemed time served. Because if an inmate is ordered released from department custody without a change to the sentence, then it's at that point where there is a separation of powers issue because the court is determining where an inmate who is serving a sentence is serving their sentence. So that creates a problem for separation of powers on that. That, of course, can be mitigated if the release order is also accompanied by either a stay of sentence, a deemed time served sentence, or a revocation of sentence. The second comment that I have about the master's report, and this goes to both section 3 and 4.
Now joining, name not recorded.
The Department of Correction also has duties under Chapter 258B to notify crime victims. The release proceedings, the individualized release of sentenced inmates proceedings don't provide for notification to the department that an emergency petition has been filed. I think that needs to be added so that the department can timely notify victims of the potential release of one of its inmates rather than trying to play catch-up for an inmate that's already been released. Note in Section 4, it says nothing relieves or suspends the obligations of law enforcement to share information with crime victims. So there should be a requirement that where a petition is filed, the custodian has to be notified as well. The third and final observation about the master's report, Section 4 says that if an inmate has more than 180 calendar days left on his sentence, the primary court trial judge shall order that the inmate return to custody within 14 days after the declaration of the state of emergency is lifted. Historically, Massachusetts, in contrast to the federal system, does not have inmates self-report to facilities, and I can see a lot of potential difficulties happen here. What I would suggest is that this has to change so that an inmate reports to court and is transported as if he or she were a newly committed inmate to the department's reception center, either at MCI Cedar Junction or MCI Framingham. So relating those overall comments and observations, I'd like to open it up to questions.
Thank you. Justice Gaziano.
Thank you. Mr. Anderson, one thing I wanted to pick up when I read the papers was something from the parole board. In what I had, and correct me if I'm wrong, but what I had recall reading was that the House of Correction parole hearings had been, there have been some problems with them, and I think only Barnstable County, they were doing them telephonically, and it seems to me that if we're trying to reduce House of Correction population and given the shorter sentences in the House of Correction, that might be a rife area to get people out of the jails. Can you talk to whether or not there are plans or what the status is of parole hearings being conducted at the houses of correction?
Justice Gaziano, I think it would probably be best that the chair of the parole board, Gloriann Moroney, is on this call, and I would suggest the question would be better answered by her.
Good, thank you. If we could hear from Ms. Moroney, thank you.
Absolutely. Good morning, Justice Gaziano. We've had tremendous developments actually over the weekend since my affidavit was provided. I'm pleased to say that over the weekend we were able to develop a WebEx connection which allowed for hearings to take place completely remotely. That began yesterday. We were able to conduct hearings in both state as well as county facilities remotely, and they are actually happening right now as we speak. We had 2 houses of correction scheduled for today. I believe the first one has concluded. That would be the Middleton House of Correction, and the second one was scheduled to occur as we speak at the Dedham House of Correction. As of right now, I have heard no issues with connectivity, and they are being conducted as planned and scheduled.
And beyond that, is there a plan so that we don't run into Article 30 issues to fast track the resolution of those hearings?
As far
especially in the district court, to get decisions out and people released if they're going to be released.
Absolutely. We certainly have the notification requirements as well. So if an individual receives a positive parole vote today, the release date would be on or after a 2-week date due to the need to approve a home plan and also notification to victims or any query petitioners.
All right. Thank you, Ms. Moroney.
Thank you.
Those were all the questions I had, Chief.
Justice Louie.
Yes, thanks, Chief. If I could ask Ms. Moroney a question before Mr. Anderson. Ms. Moroney, is there any opportunity for inmates at the House of Correction who may have previously decided that they wanted to wrap up their sentence rather than seek parole to be able to reconsider that decision?
Good afternoon, Justice Lowy. At any point, even prior to the pandemic and certainly now, if anybody wanted to submit a reconsideration for a hearing that they previously postponed or waived, they absolutely can do that, and that's absolutely something that we can accommodate, especially now due to this development with our technology.
Okay, thank you very much. Mr. Anderson, you've made some comments that are consistent with a number of the sheriff's affidavits. Sheriff Coffinger wrote in his affidavit that release from incarceration, that many inmates frequently rely on homeless shelters, soup kitchens to meet their daily needs. And we're not infectious disease doctors. How do we, gauge the increased risk to inmates and to people who are not in prison? What means do we have to be able to do that? Justice Budd asked some questions about testing that might be available, and I'm not sure we had a good answer to those questions. Any thoughts on that?
Well, I think the settlement master's report does a good job in terms of for sentenced inmates. These are individual release petitions, so I think that the court should have the opportunity, even in these expedited hearings, I'm sure counsel will have some opportunity to provide the information to the judge who would be making this decision. I think that's the way it would have to work. And as I said before, bearing in mind that when reentry planning begins in earnest at the 1-year mark, I would expect at that point, department staff would have begun those conversations with the inmate to be released to determine what type of support services they need when they're out. What is their housing going to look like? What is their access to medical care going to look like? So I think to some extent the settlement master's report takes care of that concern by having it be an individualized assessment for sentenced inmates. And I think probably the best approach to take on that.
All right. One last question. We've read a number of the affidavits that arrests are down, and this recommendation and report certainly creates a process through which we may see a significant reduction in pretrial detainees. If that were the case, is there a means where the Department of Correction can enter into some sort of cooperation agreement with the sheriffs where appropriate, committed folks who are already sentenced might be able to be moved if the population is reduced in the jails?
I'm certain there is the capacity to do that. The department has existing agreements with the county sheriffs to step down inmates from DOC custody to county custody as they near the end of their sentences and are going to be released into the community. So, depending on what the number of the classes and the reasons are, I'm certain these agreements can be modified or enhanced so as to provide for the scope of services that's needed based on the cohort we're looking at.
Okay. Thank you very much.
Thank you, Justice Bud.
Hi, I just had a question for Attorney Anderson. Did you say that right now there are only cases at the Massachusetts Treatment Center?
That's correct. 17 as of this morning. It was 10 Friday with 13 quarantined, and now the tested positive number is 17.
Okay, thank you. Nothing further.
Justice Seifer.
Thank you. For Mr. Anderson, can you tell me, on page 9 of the master's report, there's a section 5, reporting by prisons and jails, and there's a recommendation that the reports be made Tuesday and Friday by 5 p.m., and then there are a number of things that should be reported on. Do you see any problem doing that, and is there any objection to it?
I don't see a problem doing that, provided that I note that the reporting is to be done by each facility. I would suggest that most of the information provided in this report would need to be provided centrally by the department for each of its facilities. So in other words, rather than getting 17 different reports from us, you would get one report listing for each facility, the information. There's going to probably be some difficulty just keeping up with real time. I'm thinking in terms of the availability of the test kits and the swabs, thermometers. Those numbers are going to fluctuate pretty regularly, so I think there'll be a real-time issue there. Overall inmate population should be relatively easy to provide. And tests may fluctuate. The measures being taken, that's probably going to remain consistent between the reports. I don't anticipate that would change. And then the number of inmates released, we should be able to provide that.
Okay, thank you. No further questions.
Justice Caffey.
Mr. Anderson, I found your presentation very helpful. I had a couple of questions. I can't tell how supportive you are of. It sounds like you're pretty supportive of the master's report. I'm just trying to get a sense. Can you do what's in this master's report? Justice Seifer asked that particular, but besides the what happens after 180 days and some other release protocols, are you comfortable with the way this reads? Is the department comfortable with the report?
Well, I just want to say something at the outset. The department didn't seek the relief that's being requested in the petition. Right. And the department's position is that we can care for our inmate population. It's pretty clear from the affidavit that we're far from overcrowded and every facility is operating with vacancies. So, it's one of those things that being said, reviewing the special master's report pragmatically, the Department of Correction releases inmates from its custody every day. The concern that I have, or the department has, is that if we're talking about large categories, that's going to overburden our central day computation unit in preparing their release packets. They're required to notify victims. They're required to notify external criminal justice agencies. For example, if a releasing inmate is wanted for a pending criminal charge in another state. Victims have to be notified. For those inmates who have ICE detainers, they need to be notified as well. There are, I think if we're talking about individualized petitions by sentenced inmates, I hope that that is something that we as a department can keep up with. If, however, the large categories of pretrial detainee releases is somehow transformed to work towards sentenced inmates, there's going to be some difficulty in keeping up with those categories. Bearing in mind we do have experience with sort of the large-scale release of inmates over time, both relating back to, the Hinton and the Farrak drug lab issues. So there have been, and also implementation of the 2012 Criminal Justice Bill. The department has experience in promptly and efficiently processing ordered releases, but it does kind of go to scale at some point. So that's just something to take into consideration.
And my other question is, so right now the problem seems manageable because it's focused on the treatment center. You mentioned this sort of epidemic plan you had, epidemic control plan. I mean, if this spreads widely and quickly, when we're looking at the record here, you just can't maintain spacing in a lot of these facilities, given how people are bunked and how they eat. I'm just trying to understand is what that epidemic control plan, how it works. If one of the larger jails becomes sort of inundated with this, what happens?
Well, generally speaking, the epidemic control plans require each superintendent to develop a method of responding to an epidemic specific to their facility, its population, and its physical plan. So these plans have already been developed. How it works is that generally speaking, it works to isolate and contain, those inmates who are either tested positive for COVID or have displayed symptoms for it. Each facility has identified units that it would use for the quarantine of symptomatic inmates or those who've been diagnosed positive. So each facility has the ability to handle even a large spread within its own population, bearing in mind that, in contrast to out in the public, inmates, COVID-positive inmates can be relatively easily isolated in certain units in correctional facilities. They can be completely separated from those who are not positive. And they also have access to health care inside their facility. So in those two regards, the department is uniquely positioned to protect its inmate population and to prevent the transmission and spread within a correctional facility, as well as the steps the department has taken, such as not transferring inmates between institutions, reducing every facility to a single point of entry, and doing enhanced screening of anybody who enters a correctional facility, also minimizes the possibility of spread or transmitting between facilities.
I remember reading, maybe it was one of the prisoner briefs, saying that Shattuck has, 25 beds and, certain 20 of them are already occupied. So I'm just trying to get a comfort level. We're reading the newspaper stories about how these various homes become sort of a cluster of coronavirus cases all immediately. But each one of these facilities has a plan to isolate and treat if that type of conflagration occurs. Is that what you're saying?
That's correct. Each individual facility has its own plan, which is audited and reviewed by the department to make sure the plan is complete. I just want to note that there has not been any COVID-positive inmates transferred to the Lemuel Shattuck Hospital. There have been COVID-positive inmates who have been transported to outside hospitals, which is the approach the department would take for those whose medical needs can't be provided for in their housing facility.
Thank you. That's all I have.
Thank you.
All right. This is Chief Justice Gantz. I had thought, going back to the 17 who tested positive at the treatment center, I thought that there was a positive at MCI Shirley. Is that not correct?
No. There was not a positive tested inmate in MCI Shirley.
All right. And at the treatment center, how many got tested positive as of the 24th?
The 24th, I believe it was...
When this case was first filed?
I believe it was 7 or 8, if I'm not mistaken. It was 10 as of the time of the affidavit on Friday.
And of those they were kept with individuals who indicated some symptoms but had not yet tested positive.
Those COVID positive tested inmates were kept on one single unit, C1. Other inmates who displayed symptoms were actually given quarantine protocols where they were kept in their cell. They weren't permitted to leave the cell, and they were provided with food in cell and medical care in cell. So it's not until somebody's actually tested positive that they're removed from those quarantine protocols and then brought to the C1 unit so that they're with the other inmates who tested positive.
So the concern, of course, is that, as you mentioned, since these individuals are being treated at regular hospitals, that if there were to be a cluster in a facility, then that would be burdening the emergency rooms and the ICUs of public hospitals, correct? Or of non-prison hospitals, correct?
It depends on the severity of the care needed for the number of individual inmates. I note out of the 17 inmates who tested positive at the treatment center, 2 are at outside hospitals. So the vast majority of those who tested positive for COVID should be able to be cared for within their correctional facility with the healthcare staff and the equipment that's at their facility. It's only in those circumstances where their conditions are sufficiently serious that they can't be adequately treated for at the facility that they are transported to outside hospitals.
Okay.
And we do have those existing arrangements with outside hospitals. They're aware that the person being transported to them is COVID-19 positive, and they receive the information about what their condition is and the reason why they need to be transferred and can't be cared for, with their current medical condition.
Now, the governor's March 23rd order prohibits gatherings of 10 or more in any confined indoor or outdoor space, and also urges those businesses and organizations providing essential services to allow for social distancing protocols. Is that order being honored within the DOC?
Yes, the way that it's being honored is that inmates released from their cells on recreation are limited in numbers. So what happens is the overall period of recreation has been extended because fewer inmates are allowed out of their cell at any given time. At most facilities now, I believe they're being fed on unit or in cell. They're not going to the chow hall where they did in the past. Outdoor recreation, I'm not quite sure. I think that's also being limited in terms of the numbers permitted to go out, and the inmate classes, as shown in the exhibits to the affidavit to the commissioner, have been advised of social distancing protocols, and officers are instructed to keep those. That the inmates who are released from their cells are keeping those protocols. Hand sanitizer, as described in the affidavit, is readily available. The inmates are being provided with soap. Those types of gatherings are just, they should. I don't think they're happening. I don't think any more than 10 inmates are being released on any tier at any time.
How about when they're sleeping?
Well, when they're sleeping, I mean, it's by virtue of the physical plant of where they're staying. If they're in a single bunk cell, they're in a single bunk cell. Same with the double bunk cell.
Right. What share of the persons in DOC are in single bunk cells?
I don't know. I don't know the answer to that question. We can
ballpark.
I would ask the court that I be permitted to file a supplemental filing concerning that, because I'd rather give you the accurate information than something I'm just guessing.
Okay, but you recognize that if they're not in single bunk cells, then of course they can't possibly be maintaining social distancing, at least during the nighttime hours.
That's correct. I think that's a problem that probably is very similar to non-correctional facilities and frankly some households.
Okay. So, now, let me ask a rather technical question. I see that the DOC, in its quarterly report on the status of prison capacity, measures the percentage of capacity by design-rated capacity. And only design-rated capacity. Is that the appropriate measure in which to measure the I'm not sure the word is overcrowding, or the crowding, or the extent to which there's excess capacity in a prison?
I'm sorry, Your Honor. The department measures it's crowded by operational capacity, not design capacity.
Well, then why does the quarterly report issued by the Department of Corrections only speak of design-rated capacity?
If I'm not mistaken, I believe it's that they're required to respond with regard to the design capacity. You'll note that the exhibits attached to the affidavit of the commissioner shows the weekly count sheets for the department, and all of those contain the operational capacity of the facility.
Okay,
just departments.
I'm sorry. Go ahead.
Sorry, Your Honor.
No, go ahead.
Please.
Design-rated capacity is the capacity for what a prison is designed to hold. It is meant to reflect the appropriate level of capacity for a prison, correct?
I think it's meant to reflect...
Now exiting.
David Kravitz for the Attorney General.
I think what it's meant to do is to measure what the capacity of the facility is, when it's architecturally designed and based on what its intended purpose is. Given that so many of the Commonwealth's correctional facilities have changed their purposes and their missions as they've been operated, I'm not sure that the design capacity is probably the most accurate way to reflect, how a facility should be staffed, or I should say how it should be measured. For example, the Department of Corrections facility at MCI Cedar Junction before 2009 was a maximum security facility prison. Since that time, it's been operated as the department's reception center. So it's the actual design of the facility is so much different than how it's operated. I'm not sure of what utility the design capacity is in terms of assessing what a facility is now and whether it's crowded.
Okay, so you're telling me that the DOC quarterly report, which measures capacity by design-rated capacity, is just wrong or is foolish to do that? And that is using the wrong. I mean, I'm perplexed. This is how DOC itself measures its capacity, and it uses design-rated capacity in its quarterly reports. And you're telling me that that's just wrong. It should not do that.
I'm not saying it's wrong. I'm saying that I believe that that's what's required for us to report. I do believe the operational capacity, which is reflected in the weekly count sheets, is more accurate in terms of how a facility is being used and operated, and what is the space available to house inmates in it. I certainly, and I'm sorry, it's a bit beyond my knowledge as to why the quarterly reports show design capacity. It may be try to be consistent between department facilities and county facilities. I don't know. I'm sorry that I don't have the answer to that, but okay. I do know that the department in its weekly count sheets, which have been attached as exhibits to the affidavit, tries to do the most accurate measurement it can with regard to its facility, and thus uses operational capacity.
Because the design-rated capacity, I believe, would be 97% right now for DOC, or I'm sorry, 98.3%, but you say it's only 73% of its operational capacity. So it gives very different measures of excess capacity, correct?
That's correct. Yes, the design capacity and the operational capacity will be different. because the design capacity is established at the point before the facility is actually used, whereas operational capacity, I do believe, takes into account, changes made to the facility, whether it's the addition of modular units, whether it's changes in unit operations. But, I mean, as you stated, it's clear that even under design capacity standard, the department is at less than 100% capacity.
Now, do you agree that reduction in population provides more flexibility and more ability to quarantine individuals as may become necessary over the next few weeks or months?
It may on some scale, and it really kind of depends on where the inmates are being released from. For example, if they're being released from NCCI Gardner, which I believe is currently at 95% operational capacity, that's going to make more of a difference than inmates being released from South Middlesex Correctional Center, which is now at 35% operational capacity. It really comes down to the individual facilities, where they are, and how they're operated. As I stated before, the department's position is that it can care for the medical needs for the inmates who've been housed, who've been sentenced and are housed within its prisons.
And is DOC or the parole board doing anything differently in terms of accelerating the release of prisoners in the wake of the COVID-19 pandemic?
As far as the department goes, I mean, our release procedures have remained the same in that they're released on the date that their sentences have expired, and we follow a protocol which includes the notification of external stakeholders, running of an active NCIC BOP warrant checks. Those procedures remain the same. Inmates are released the day that they complete their terms of sentences.
Okay, so there's no increase in the rate of furloughs?
No, there isn't.
Is there any effort to examine whether furlough is appropriate for any inmate?
I don't believe
the pandemic?
I don't believe there has been, and I believe because furloughs generally are sponsored and they're programmed and they're timed for a certain period of time. I think it's not to exclude 7 days, so I don't believe the department can even contemplate under its regulations a furlough that would exceed that period of time and one that basically is open-ended. I just don't think it's within our capacity or ability to do that.
Okay. With regard, this may be a question from Ms. Moroney. With regard to those who are granted with parole, are there any who have been granted parole who have not received parole permits?
Good afternoon, Chief Justice. The individuals who, as of the hitting of the pandemic, if there were individuals that were awaiting a positive parole vote from the parole board, primarily individuals who are serving life sentences, those decisions were accelerated such that in the event, again, if they were awaiting a written decision from the board, those were accelerated and have been provided to those individuals within the past week and a half. So those were the individuals that were waiting for a vote that are now no longer waiting. That was done in a way that those individuals understood that they were waiving any ability to obtain a detailed administrative decision, but they did indeed accept that and wanted the accelerated decision. So those have been done.
But my question was, there's a difference between a vote to release somebody on parole and the issuance of a parole permit. Are there those who have been released on parole but for whom parole permits have not issued?
Yes, my apologies. There have been, and I think it was in my affidavit, there were, as of Friday, 62 parole permits as of Friday that had been issued, and those individuals were indeed released on parole supervision.
Okay, my question actually is different. How many have the parole board voted to release, if any, who have not been issued parole permits?
I believe, as of right now, well, let me ask for clarification, Chief Justice. Are you speaking of in the past 2 weeks, or just all total?
Well, no. I mean, I'm asking for how many individuals basically the parole board has said, okay, you're authorized for release, but has not issued the parole permit which would actually release them.
There are currently
pending right now.
There are currently, I believe it's 300 individuals who have received a positive parole vote that have received that vote, but the vote included a reserve date, which would include the time frame to approve the home plan and to notify any victims or query petitioners. That's typically about a 2-week time frame.
So there are 300 individuals for whom parole has been granted, but they've not yet been released. Is there any effort to accelerate that and to expedite that so as to get those 300 individuals released and therefore reduce their numbers in the prison population?
We've made every effort to ensure that home plans are being reviewed and approved as soon as possible, those who are within the ability of the board, and certainly making the notifications. There are some individuals in there as well who perhaps need assistance with home plans. That we're certainly working with them on. There are also individuals who, within that group, received parole to from and after sentences that haven't been effectuated yet. So that number includes many different factions, but where we can assist, we certainly have and will.
And has there been any acceleration, as Justice Graziano made reference to, any acceleration of parole hearings? That is, we're going to hold parole hearings at a greater volume than we have before in order to see whether individuals are appropriate for parole and appropriate for release.
Not outside of conducting hearings within the parole eligibility date.
So best I can tell from what you've answered, all that parole has done is to attempt, where there have been parole arguments in parole hearings, you've attempted to expedite decisions, but you haven't attempted to increase the number of parole hearings nor changed the expedition of the issuance of the parole permits in the wake of this pandemic. Is that correct?
I would say the parole has made a drastic effort to continue to maintain the operations of the agency and work within the confines of our statutory provisions.
Okay, but that's not my question. My question is not whether you're seeking to maintain. I'm sure you're attempting to maintain as best you can. My question is there any attempt to accelerate or expedite either parole hearings or the issuance of parole permits in order to move these individuals more quickly who are appropriate for parole release but who have not yet been released?
No, aside from creating the option for video conferencing, which we have never had before, no, not outside of the confines of the statutory authority.
Okay. I have no further questions. I'll turn it back to Justice Graziano.
No further questions, Chief. Thank you.
Justice Lowy.
No further questions, Chief. Thank you.
Justice Budd.
I'm all set. Thank you.
Justice Playfer.
No, thank you.
And Justice Caffrey. All right. Thank you, Mr. Anderson, and thank you, Ms. Moroney. We'll turn now to Elizabeth Riley on behalf of the Suffolk DA's office.
Good afternoon, Your Honor. Chief Justice, this is Donna Patalano, General Counsel for District Attorney Rollins. I'll start off the argument and handle the legal pieces. Deputy Chief Liz Riley is on the ground in the District Court and the Superior Court and will have answers to factual questions that you have. I'd like to start by saying that District Attorney Rollins, who is on the line, acknowledges the report of the Special Master and thanks all of those who chose collaboration, looking for a negotiated resolution in the midst of this frightening pandemic. We recognize the urgency here. If we look at Rikers, the correctional facility in Rikers, there was a report just this morning that it has 7 times a higher rate of infection inside that correctional facility than exists in the New York City area itself, which is the heart of the pandemic right now. So certainly these are not ordinary times. Decarceration in certain instances, like these exceptional circumstances, is the just and humane way to protect the vulnerable by allowing social distancing that can't possibly happen if they have to stay where they are now. We can and must, though, do this without losing sight of the needs of survivors and victims pursuant to our obligations under Chapter 258B and our obligations to treat them with dignity and respect. Decarceration, I'd like to know, also protects those who work behind the walls. There has been some discussion this morning about inmates who've been diagnosed with COVID-19, but left out of the conversation is the correctional officer in Shirley who's also been diagnosed with COVID-19, we understand. And so the moves we're making here to decarcerate certainly protect both inmates and people who are working behind the walls. In Suffolk, I'd like to say we're not just ready to go, we're rounding the first bend here. Thanks to the Mass Bail Fund who provided us and CPCS and the Suffolk Lawyers for Justice with lists of those who are in the jail, we are in the process of expedited hearings. And one of the reasons why we are excited to be at the table with the special master trying to negotiate a resolution. We recognize the burden that reentry puts on the Department of Correction and the Suffolk Sheriff, but this is no longer the time for the status quo. There is no comfort level to what's going on here. There is just an urgency. I will note that just within the last hour, a federal district court judge in Pennsylvania, John Jones, ordered the immediate release of all ICE detainees, So again, this is not the time for the status quo. We do ask, though, that this court order take a leadership role with the order so that there's some consistency across the Commonwealth. And we ask, too, that the agreements between district attorneys and the defense par go directly to the single justice. In fact, we've had some experience in Suffolk County with agreed-to motions in the last 2 weeks being denied in a court in Suffolk County. And the court has evidence of this in the affidavit by Attorney Kiley in paragraph 7. So I have to respectfully disagree with my brother from the Attorney General's office. There are agreed-to motions that are being denied, and that is why it is important that at least for those agreements we go directly to the single justice. I'd also like to say that we are strong supporters of the reporting requirement. It's critical that we have that reporting requirement so that we can be nimble, and we ask that that include tracking of racial racial composition of the people who are released. This court has already recognized that there are disparate impacts on people of color, especially black and brown members of our community, and we need to be nimble when we see that whatever agreement is put in place presents a problem that adds to those disparities. It is part of the reason why in our pleading we did talk about the failure of data sharing under Chapter 6A, Section 18 3/4, and one of the reasons why we've had to rely on outside partners to get some information. Although I do want to also recognize that the Suffolk Sheriff's Office and DCGIS in particular have been extremely good in the last 2 weeks and really back to January to share some of the data. But we do need more in these exceptional circumstances. I'm going to open it up now for questions. And again, Deputy Chief Liz Riley is here, who has been handling most of what's going on in the ground.
Thank you. Justice Gaziano.
I have no questions, Chief. Thank you.
Justice Louie.
I have no questions, Chief. Thank you.
Justice Budd.
I'm all set. Thank you.
Justice Seifer.
No, thank you.
And Justice Kafker.
I'm just trying to understand, does the Suffolk VA fully support the Special Master's report then?
No, Your Honor, there are some issues that we have with the special report. In general, we are in support. of the negotiated resolution. But we do believe, again, that the racial compensation should be put in there. I apologize, I keep tripping over that word. And there is, if some of the exemptions are removed that were asked of by the petitioners, we would say that at least an exemption should be put in place for murder, for first-degree murder.
I'm confused. You want first-degree murder to be what?
So that it would be one of the exceptions provided in the addendum.
Are you disagreeing with the gist of the exceptions, or are you in agreement with the gist of the exceptions?
I would say that our general response has been that we do have concerns, as have been expressed by the petitioners, that the exceptions will swallow the rule. The most important message that we would like to come in the order about the exceptions is that this is just the floor, that it provides an opportunity for counties to just use this as the floor, and it is not the ceiling, that it doesn't preclude agreements between parties to be put forward to the single justice when it's appropriate and is responsive to both the safety of victims and witnesses and community safety.
I have no further questions.
I've got one question. You made some reference to racial composition. What would you be suggesting that be done with regard to matters of racial composition of those released?
Well, our concern, Your Honor, is just that we have the data and the information in order to be nimble. If we find that by the end of the week or by the end of 5 days, let's say, or the first reporting requirement on Tuesday, that the only people who are being released are those who are affluent. To give you an example, we just got some data from the House of Correction in South Bay, and in there we have 62 people who were released over the last 2 weeks from March 16th to March 30th. Of the 62 released, all were women and 72% were white. That is challenging, I think, and we would need to really understand why that's happening. Some of those were sentences that were wrapped. They weren't based on requests. So I'm not saying that, any of it was done in an intentional manner, but certainly we need to understand that we have equity in the way that release is being provided to detainees and inmates.
And I guess you made a reference, the MCI Shirley confusion. You're telling me that it's a prison guard who's tested positive, not an inmate?
Yes, Your Honor.
I see. So that's where I'd heard about MCI having somebody who was positive, but turned out to be a prison guard. I have no further questions. Anybody else have any questions, Justice Gaziano?
I have a follow-up question to a response to Justice Caffrey. Ms. Patalano, I'm a bit confused. With respect to the exemptions, and you mentioned the crime of murder, is it the DA's position that murderers should be released under this program?
No, that should be an exemption, at least for the floor. At least for the floor.
That they should be ineligible to be released.
That they would not receive the presumption of release. And again, in our eyes, the presumption is merely the making of a list, right? We're just putting the list together so that we can very quickly and efficiently go through, as we have been on the ground here in Suffolk County since this happened, and District Attorney Rollins has been a leader on that front and have responded in a very quick and expedited way.
But you mentioned murder case, so you want the flexibility to be able to move to have murder defendants released, if you want to.
No, we want that to be put into the exemptions, the excluded offenses. It doesn't mean, Your Honor, that above and beyond disagreement that we wouldn't necessarily find a particular person who's been convicted of murder. I think one example that I gave to the special master is if we had, for example, an 84-year-old.
As far as a look back, I get you now. I was misunderstanding you. Okay, I get you now. All right, thank you.
Thank you, Your Honor.
Yep, I understand.
Justice Lowy?
I'm all set, thank you.
Justice Birch?
Just in terms of the question about exemptions, are there others aside from first-degree murder that you that you would say should be ineligible for consideration?
No, Your Honor.
Okay.
Again, our concern is really that there are so many exceptions that it will swallow the rule, and that we want to be sure that this is just the floor, and it allows us to come to agreements with the defense bar on other individuals on a case-by-case basis, taking the careful review that we've already been doing in Suffolk County.
Thank you.
Justice Seifer.
Nothing, thank you.
Justice Kaffer?
All set.
And I've got no further questions. Thank you, Ms. Patalano, and thank you, Ms. Riley, for being available on call.
Thank you, Your Honor. If I could just say one other thing, we've said many times, but Rule 29, we do believe should be in the form of a stay. I agree with a comment that was made earlier from the bench that it's an inartful and doesn't really fit well, but it's the best that we see outside of using just your authority under Commonwealth v. Charles.
Okay. I'm sorry. It's a better vehicle than to use the authority to stay under Charles, or you?
No, we believe Charles is the first. I apologize, Your Honor. We believe Charles should be the first step, and it is the most flexible and way for the court to place the order. And then if it is under Rule 29, that it would have to be formed in a stay in order to avoid separation of powers concerns.
Your preferred course of action would be for us to do it as a stay of execution of sentence and not as a revision of the sentence.
Yes, Your Honor, and it, I think there'll be further litigation about whether or not we would be able to do a agreed to plea at the end of the stay. To be flexible and nimble in the face of this global pandemic.
Yeah, one other further question, actually, that you made reference to. So you agree, you have cases in which you have agreed that somebody should be released. Is there any view that a null pros on your part can't be changed? I mean, is there any capacity to do a null pros during the pandemic with the view that you could prosecute afterwards?
Your Honor, we're considering that. I think there's some dicta in cases in the 1920s that essentially says our power to null pros ends with sentencing. I'm not sure if the extraordinary circumstances that we are facing now would be the right way to move forward with a null pros and litigate that ability, but that's something that we've been considering, especially, for those who are post-conviction who have been sentenced.
You'd be asking for us to address that issue in a decision potentially?
There is some potential, yes, Your Honor. The case is not yet teed up, but there is some potential that will come your way. And certainly with the district court and superior court pretrial cases, using a null pros is something that we're considering, but again, we need to take these on case-by-case basis and considering the incident, the charges, the victim and witnesses, and community safety.
Okay, thank you. Thank you, Ms. Patalano. Thank you, Ms. Riley. We'll turn now to Mr. Ralph on behalf of Berkshire Middle District in the Northwest.
Good afternoon. May it please the Court. Middlesex, Northwest, and Berkshire are proud to stand together on this effort. Moreover, Middlesex brings to this the experience of already having collaborated with Sheriff Katusian to handle motions that to date have resulted in the release of 63 inmates. Our office and the sheriff have also already prepared a list of eligible prisoners and are ready to proceed immediately with the consent judgment. By seeking to release certain nonviolent offenders in order to reduce the risk of contagion, we're following the approach that other jurisdictions in our country have already taken. Other nations around the world have also recognized the enormous threat that coronavirus poses to people who are incarcerated and have taken the same sort of action that we are urging today. The United Nations Commissioner for Human Rights has urged all countries to immediately take steps to release vulnerable and low-risk prisoners. Canada and Germany, two other comparable democracies, are releasing thousands of nonviolent offenders held pre-trial or nearing the end of their sentences. This agreement also ensures that justice will not be denied to victims, their families, and the communities that we serve. Once the epidemic is ended, we will proceed with the pending cases, and convicted defendants with time remaining on their sentences will still ultimately serve the remainder of those sentences. It's undoubtedly going to be challenging to take the type of decisive action that's required to preserve both public health and public safety in this unprecedented time. Yet, it's precisely those difficult decisions that will define us in the coming days. As ministers of justice, we have a moral duty to protect both the public and those who cannot social distance or otherwise protect themselves. Science, statistics, and justice all require that we implement the sort of solution proposed here. We respectfully request that the court accept the special master's report and recommendation. Before opening up to additional questions, I want to address a question that I believe Justice Budd asked Assistant Attorney General Haskell, which seems like a long time ago. She asked about the feasibility of pre-release testing. Our office has already consulted with and retained an infectious disease doctor to assist us in our evaluation. And based on our discussion with that doctor, this is apparently a conundrum that even hospitals are struggling with on a daily basis. For instance, surgeons who presumably should not be COVID-19 positive are sometimes urged to take a test before they do surgeries. The problem is that the results of those tests can take days to actually return. And during the time that the tests are pending, of course, the doctor is going to be, circulating with other potentially infected people. It's the same problem that you would have in any of the prisons or houses of correction. You can test an inmate before they're going to be released, but then while those test results are pending, you would potentially be returning them to the same infected environment that they came from. So that is a conundrum that even the infectious disease doctors do not have a ready solution for. Therefore, the proposal that is in the agreement at this point may be the best solution that we can craft. And then just to clarify one point that was raised in the last argument with respect to murder, the very first excluded offense in Appendix A are crimes of violence. There's no serious question that murder is a crime of violence, so I don't think that there's any legitimate dispute that someone who committed murder would be categorically excluded. At this point, I'd open up to any questions that the court might have.
Thank you. Justice Galliano.
Actually, that's why I asked the question about murder, because I had assumed it was a crime of violence. But so you buy into the entirety of the master's report?
Yes, I mean the master's report, to be honest, was a negotiated document, and anytime you enter into negotiations, you like some things and some things you accept. On balance, we believe that the master's report is carefully crafted and balances the interest in the community and safety, along with the interest in prisoners and officials at the houses of correction and prisons, and also their safety from infection from this epidemic.
Well, then let me ask you particularly about the Article 30 concerns that have been raised about altering Rule 29. What's your position on that?
My thought is that, as everyone has said, there is no great fit. This is an unprecedented circumstance, but I don't think that
isn't the case sometimes when it's a great fit not to violate the Constitution?
No, I don't think that this does violate the Constitution. I don't think that applying Rule 29 would violate the Constitution. And I think that the reason why it doesn't violate the Constitution is essentially what the court would be doing would be considering this matter almost nunc-pro-tunc. And the point of that would be to effectuate the original sentence that the judge initially intended to impose. At the time of the sentence, the judge presumably thought that he was sentencing or she was sentencing the defendant to prison as that is commonly understood. Unbeknownst to anyone, particularly the judge at that time, prison as it is commonly understood would not exist. Therefore, in order for the court to effectuate the intent of the judge at the initial sentencing, the best way to do that would be to bring it back to the trial court and let the judge consider what is the appropriate sentence in light of the epidemic that we are now faced with.
And that also holds true if a person in you know, this could be wildly off, it could be accurate, I have no idea, nobody knows. If that person was released from serving a sentence and the facility that they were in never miraculously gets a single case of COVID-19.
That's right. But it's not about getting a single case. It is about whether the trial judge, intended to expose an inmate to this drastically enhanced risk of infection and death. I think that is different from the situation where there's a separation of powers issue, because this isn't a result of anything that the defendant may have done after the sentence. This isn't a result of something that would be supervised by parole. This really is effectuating what would have been the judge's intent had the judge been aware of circumstances that would drastically impact the effect of the sentence that the judge sought to impose.
I have no further questions. Justice Lowy.
Yes, thank you. Mr. Ralph, you mentioned Germany and some other states. Are you aware of how that prison reduction took place? Was it the executive branch? Was the judicial branch involved? And if the judicial branch was involved, to what extent?
Your Honor, we've actually done a worldwide survey of various countries. I have to say that I can't talk about the inner workings of all the different countries, but I can tell you that there's obviously different legal frameworks, different mechanisms. There are, it is the legal systems are so different that I can't comment on the specific mechanisms. But what I can say is that comparable developed democracies around the world are considering and implementing exactly the type of approach that we are suggesting that would be appropriate here in Massachusetts.
All right. You are the executive branch, though, and I appreciate that you and the other parties in good faith worked with the master. I also expect that those DA's offices that didn't also did not in good faith based on their view. But there's nothing at all that precludes an elected DA from agreeing to a reduced bail or no bail, agreeing to a motion for new trial and then a time-served plea or null pros, or agreeing if it's within 60 days to a revise and revoke. Isn't that right?
That is right, and Your Honor, as I started with in my introduction, we have already done that, resulting in the release of 63 inmates. We have a list right now, and we intend to proceed on that with as much deliberate haste as possible. But our authority is circumscribed by Rule 29 at this point, and that is essentially why it is that we're coming to the court. Also, it's important that we have the ability to obtain information and have some of the other procedural safeguards that are contained in the agreement. We're doing the best that we can, but we can't do everything that we could if the court was to adopt this agreement.
All right. Thank you. One last question, going back to the line of questions from Justice Graziano on the revise and revoke. Do you think if we were to adopt your interpretation of this circumstance and consider post-sentencing circumstances that would be a deviation from our case law with revise and revoke?
I think that it would be consistent with notions of separations of power. It would certainly be a different application than Rule 29 has ever been applied to before. But obviously this is a unique circumstance. This is the first epidemic that we have encountered. So it's a unique factual circumstance, but I don't think that simply because it's a unique factual circumstance, the underlying legal framework necessarily provides any barrier to it. It's just applying a different set of facts to well-established separation of powers concepts. And in this context, the separation of powers concern is with the court continuing to exercise supervision over defendants after they have been convicted and sentenced after a period of time, and thereby exercising the authority of the parole board and the executive branch. In this case, really what it is a reconsideration of the initial sentence in light of these extraordinary new circumstances that fundamentally alter the calculus that the sentencing judge would have applied at the time of the sentencing had the sentencing judge been aware of this pending epidemic or possibility of greatly enhanced risk to detainees.
Thank you. Justice Bud.
I have no questions. Thank you.
Justice Safer.
Yes, thank you. Attorney Ralph, can you explain to me why a stay is not a better idea than Rule 29, bearing in mind that if we chose to, we could amend the rule a bit to permit something like a pandemic to be considered?
That is what Attorney said, paragraph 4 of the agreement. That's essentially what it is that we are recommending. It's on page 8, paragraph 4. So it is that we're using Rule 29.
So that's not a Rule 29.
I'm sorry?
So we would not have to rely on Rule 29.
Rule 29 is the proposed legal mechanism, but as other litigants have mentioned, it wouldn't necessarily have to be under Rule 29. It's the most convenient, well-established protocol for doing it, and I think that it does avoid some separation of powers concerns. But
I guess that's what I don't understand. I don't understand why Rule 29 avoids separation of power rule concerns that Rule 6 and a stay would. Why is Rule 29 violated more than a stay?
Well, under Rule 29, it's clearly within the province of the judge to do sentencing. Once you get outside of Rule 29, then you're relying on the extraordinary powers of superintendence of the court, and I think that you then kind of step onto less firm ground. Although I think that it would be appropriate for the court to do it that way. Rule 29 is clearly established authority of the court to impose and reconsider sentences.
Okay, thank you. Nothing further.
Justice Casper. Don't we have some cases in which we've stayed execution of sentence even post appeal?
You have Commonwealth versus Charles, which cites Commonwealth versus McLaughlin. Those were both in the Dugan context.
So why aren't those closer to what we're dealing with here than Rule 29?
Well, they both involve stays. One is just a specific method of implementation. It is a different path to bring that back to the trial judge or the sentencing judge to consider it. The result is the same. It's a stay. It's just the legal tool that you're using. As I was suggesting, Rule 29 is clearly established within the bounds of the court and within the bounds of the SJC to modify the rules of criminal procedure. So I think that Rule 29 has the advantage of not requiring the court to use its extraordinary superintendent's authority over an inmate, which is potentially problematic. I don't think that it is ultimately legally prohibited, but you're on shakier ground, we believe, than if you proceeded under Rule 29.
And forget about Germany and Sweden, New Jersey, New York, California. Have these all been done through agreement, all of these release? And if not, these other courts are smart too. What are they relying on to justify this? Are they providing any rationale, or are they just doing it because it's agreed to, or are they just ignoring, not putting any reasoning in on the constitutional separation of powers issue?
Your Honor, I have to confess that we've canvassed the entire world, and we've collected dozens of reports of courts releasing defendants. We have not done an in-depth review of the legal procedures that all the differently situated courts have used. I'd be more than happy to provide research to the court.
Do any of them provide do any of them have the equivalent of Rule 29 or Rule 6 or anything else that we could look at?
I have not done the research relating to the specific mechanism that the different jurisdictions have used. I'd be happy to, assign attorneys to research that and provide detailed information. All I can report to the court is that throughout the world, this is
I defer to the chief, but it would be very useful to me. I'm not really interested in the international ones, but if other state courts have or federal courts have provided a rationale that could provide guidance to us, I would find that very useful to have.
I'd be happy to submit something.
In this particular context, yeah.
We'd be happy to submit something like a 16L letter or something, Your Honor.
That's all I have.
Hey, Justice Kafka, I assume you're referring to only post-conviction, correct?
Yes, I'm only interested in, I'm interested in the post-conviction rationale being provided by other states or federal courts in the United States.
And I guess
we will look into that and submit something. We'll look into that and submit something to the court as quickly as possible, Your Honor.
I think you'll be focused on post-sentencing where it's not pending appeal, because we certainly have authority already in the rules with regard to a stay pending appeal. So, okay, and I would invite, Mr. Ralph, you're welcome to do that, and I invite anybody else, including petitioners, who wish to weigh in on that issue. I have no further questions. Justice Gaziano, anything else?
Just one follow-up. So, looking back at McLaughlin and Charles, both of those cases involved egregious errors at trial, right?
Egregious errors at trial, right. So
right, because Charles was a Dukin case.
Correct.
And the court said, well, there was a trial error, so we're going to give you a stay.
This is correct.
All right. I've got no further questions.
Justice Lowy?
Nothing, thank you.
Justice Budd?
No, thank you.
Justice Seifer?
Now exiting.
Matthew Siegel for Maxwell.
Justice Kafka?
Nothing.
And I've got nothing. Thank you, Mr. Ralph.
Thank you.
Ms. Sullivan, on behalf of Bristol and the 6 other DA's offices.
Yes, good afternoon, Chief Justice. Thank you. The 7 DA's office strenuously opposed the petitioner's petition for the unconditional categorical release of both pretrial detainees held under lawful process and those who were convicted and sentenced lawfully. We would suggest that what's proposed by the special master imposes a layer of administrative bureaucracy that's both over-inclusive to some groups, under-inclusive to others, and puts a duty on the executive branch, that being the district attorney's office, to ferret out information and compile lists, information that we do not necessarily have or we do not have access to. Most importantly, if all this is generated by concern for the health of the inmates and the spread of a virus, then medical information relevant to that determination and relevant to the merits of whether a person is released or not needs to be accessed. And it's the Commonwealth or the district attorney's position that certainly in the cases of pretrial detainees, all of that information is solely and uniquely within the knowledge of the defendants and their counsel. It's clear that in the pretrial detainee situation, the detainees would have counsel. Counsel would be appointed at arraignment. There would be bail hearings, and then that detainee would either be released on personal recognizance or whatever, or held on some sort of bail. The district attorneys also disagree and believe it's
now joining
not productive or counterproductive and cause a waste of more time by having this presumption that is essentially meaningless if some categories of crimes can fall into the presumption, and other detainees or inmates can raise the issues anyways. We are on the side of fully align ourselves with the trial court, where they indicate that it's necessary to have case-by-case, individualized determinations of any motions to release. Those motions for the pretrial should be brought in the trial courts. The trial courts have acted expeditiously and I suggest admirably in arranging the procedures, the facilities for expediting and hearing these kind of motions. And the district attorneys have manned the courthouses in order to do that. We've reached out to our local CPCS attorneys. We have indicated, I believe all of us, it's all in the affidavits provided by our different offices, that in appropriate cases we are certainly willing to consider agreeing to releases, and that can and is happening. But we do not believe that we need in any way the type of overlay that the special master is trying to impose. And we think that it raises it certainly has to be convicted inmates serving a lawfully imposed sentence. That raises serious concerns about the separation of powers, and any change to the sentence would violate Articles 20 and 30. It's solely, the execution of the sentence is solely within the power of the executive. And you can't use Rule 29. That's not a motion to revise and revoke. It ends up being, a suspended sentence, a motion to commute, all of those procedures fall within the purview of the executive department, the governor. And that's, and one of the other points that the DAs would like to make is that once a person is sentenced under the separation of powers, the legislature makes the laws, and the criminal laws and the penalties, they set those, the judiciary adjudicates those, imposes sentence. Once sentence is imposed, the jurisdiction and the authority is transferred to the executive. And in these particular circumstances, it's not like this wasn't contemplated in the past. There is a civil defense, which we cited in our supplemental brief, a civil defense statute that entrusts the governor of the state, who is declared, when confronted with emergency situations like what we have, what he has declared we have here right now, has the authority over the inmates, for the health and welfare of the inmates. So if anything is going to be done with convicted inmates who are serving a lawful sentence, it is for the executive branch, that being particularly the governor. And I would also like to point out that I think that it's important for the court to stick to what the actual facts are as we're able to come out during this whole process. The petitioners filed a petition without having gone to the lower court to present everything. There was no evidentiary hearing about anything. The petition was filed against only one party, apparently left out the other important parties, and we proceeded from there. The goalposts at the master's reports, there's various iterations. They all seem to be moving, but initially in the petition, it was the sort of categorical release of all types of detainees and inmates. And that is what the district attorneys strenuously opposed. The process does not take into account appropriately public safety concerns. They've been articulated by the Department of Corrections, and which appears that we just have to focus on what the facts are. Yes, there is a crisis, but what is the extent of the crisis within our prison system? And I would suggest that what's before you shows that it's not at a crisis level at all. That the management of our prison systems has made it to prevent the introduction, or for the most part, or the introduction of the virus to the prison system, and certainly the containment. They have procedures in place. They have dealt with outbreaks like this before. There's a footnote in one of the affidavits about SARS, HIV, and they successfully navigated through all those types of things. So I would suggest that as far as the convicted defendants, that's solely within the purview of the executive department, the governor, and he has many other agencies, executive agencies at his disposal, the Department of Public Health, Department of Public Safety, that can all assist in anything that needs to be done with the inmates to ensure that their health is protected. And as far as the pretrial detainees, it's the experience of the district attorneys with their assistance on the ground that the procedures that have been put in place by the trial court are in fact working, and working very well. If motions are filed, they're heard expeditiously. I believe there were some within 48 hours. The courts report that they're seeing no problem with the volume, that they're able to meet it. We are doing everything in our power to, even with reduced staff, and but we are doing everything in power to meet the requirements too, and we have our court staff to address these matters, and they are being managed. And we are talking with our with the sheriff, and if there is something that we can do, that we're open to that, but it has to be in court on a case-by-case basis with individualized determination. The victims, if it's a victim crime, they have a right to be there. They have a right to be available. They have a right to be heard. They cannot be ignored, and that is something that the master's report just completely disregards. And another point that I would just like to make about the separation of powers within the master's report, if I haven't already, but it does direct that the district attorney's office, executive branch, perform certain functions for the judiciary, and I would suggest that that's beyond that is beyond the powers of the court to do. And it's not that we do not daily work diligently and hand in hand with the trial court. We try to facilitate what we can, but we cannot and should not be ordered to do something that we are not in a position to do. And if there's questions?
Justice Graziano.
I have no questions. Thank you, Chief.
Justice Lowy.
I have no questions. Thanks, Chief.
Justice Budd.
Yes, I've got a question. You said that you're aligned with the trial court's position, and I just want to hear from the point of view of the district attorneys the opposition or the problem that you have with sort of having a presumption that certain categories of inmates should not be considered necessarily a good candidates for release based on the COVID-19 virus.
But if I think I think that they create presumptions of those who would be presumptively released, but then there's a catch-all that says that we're not preventing anybody who doesn't fall within this presumption to bring a motion. So it's our position that what's the point of the presumption? If the bottom line is that everyone can bring the motion, and I think even the other district attorneys all have come down to saying that there needs to be a case-by-case review and an individualized determination. Everybody expects that it should go before a trial judge. So we're just not quite understanding the need for the bureaucratic overview, an additional one. I mean, I think if these things are going to be done expeditiously, you know, the word committee is synonymous with delay. So formulating the committee, assembling, it just seems that from our position and from reports from what's happening in the district attorney's office, the process and the procedure as it stands now is working. The courts have seen no complaints, and we're ready, willing, and able to assist in any way that we legally can. So we have obligations, we have public safety obligations that we are not going to give up.
Can you give me a sense of how many inmates have been released from each of the counties that DA's offices that you represent? We did not present any of that. I believe it's attached to one of the Chief Justice's affidavits. There's a chart of motions that were brought and what the results were, and I don't have it at my fingertips. But it is in the. It's not with our submission, but it is in the documents that were presented to the court. It might be just established, but I'll take a look. That's no problem.
Okay, yeah, I apologize, Your Honor, but I know I would ask the court to carefully review the affidavits of the trial court chief justices that were submitted, because I would hope that the court would commend the trial court for really stepping up, taking charge of the crisis, and doing what they can. The inmates are not forgotten in this process. They are the people who are getting access to the courts on an emergency basis for the most part. That's what the directives have all been. That's what the focus has been.
Do you happen to know whether there were any cases, how many, if any, cases where the government for the counties that you represent were in agreement that the inmate should be released?
Yes, I don't have the actual numbers, but are you talking about pre-trial detainees? I believe in Worcester County we have. You have what? You've had some that have been... Yeah, we have discussion and we have plans to make agreements, to have agreements with defense counsel to release people in appropriate circumstances. I don't have the numbers, or the cases on what has been done, what it is. I could probably get that to you if you would like. But we are open, certainly, to discussion. And in appropriate case, we are open to an agreement, for release. We're not precluding that at all. We're just saying that the process has to be one that takes into account all the factors. And, it should be done in open, on the record. It should not be done, in somebody's office. This is the criminal justice system, and the public has a right to know what is going on.
I'm sorry. There's somewhere in the special master's recommendation where it says that there's not going to be a hearing. I might have missed it.
Well, no, but I was just as far as how the process of with the committee works, how the committee works, assembling the list, and then presenting them and say, oh, we agreed to all this. But what's particularly concerning is if, we can't do it fast enough, and you DAs can't get a hold of the victims fast enough while we're still going forward. And that's the way it is. That's a dereliction, I think, of everyone's duty. The Victims' Right Act applies not just to the district attorneys, but it applies to the courts. There are specific directives to district attorneys and other people. But the bottom line is that the victims should not be just dismissed as part of the process. They're very important. And as part of, any decision to release somebody who has been held on bail and, for changed circumstances, you have to consider where they're going, what they're going to do. Is it a domestic violence situation? Is their only home back to where that violence occurred? there are facts that have to be fleshed out.
I think there's an exception for that, but that's fine. And then the position is that no one who's been convicted should be considered for release, even if it's nonviolent offense or close to their wrap-up period.
What we're disputing is the authority of the judiciary to essentially usurp the power of the executive that way. Look, certainly if there was in the 60-day window of a Rule 29, that's fine. Anything else, once that sentence becomes final, you're asking to commute, to suspend, and you violated the separation of powers.
Right.
A stay of execution pending sentence, that's appropriate. A stay of execution when there's a validly filed Rule 30 or Rule 30A motion, that would be appropriate. But apart from that, there are remedies, and I think in particular in circumstances like here where we are facing a crisis, a health crisis, as directed by the governor has the authority to do what may be needed under the circumstances. No one has even, attempted to go through the governor or even to suggest that. But I suggest that that's the authority there. That executive authority is how you would be able to effectively deal. The governor is in charge of parole. The governor is in charge of public safety, public health, and to the extent that things like that can be had. And he's in charge of the commutations and the pardons. And if that's what needs to be done, then that's for the governor to be presented with and to make that determination.
Okay, thank you.
Justice Seifert.
Nothing, thank you.
Justice Gafter.
Just want to make sure I understand the position. So it sounds like you're thrilled with the way the trial courts are handling this and you're completely comfortable with the procedures in place. Is that right?
Well, nothing has been brought to our attention that the procedures aren't working as they should be working, that people are precluded from bringing motions, that people are delayed in bringing motions, that someone is suffering as a result of anything, and we are open, to whatever information.
And you're comfortable with the hearings as they're being conducted, which is by video conference or teleconference. So you're comfortable with that as well, right?
Yeah, yes. Certainly it's not ideal, but under the circumstances, that's what has to be done. And that's what we're doing. Our office, yes.
Right, and then the other, so you recognize we do have a health crisis out there, but you think it's under control in the prison systems. And what is the DA's office? Are they doing anything differently in response to this than they were doing before? I'm just trying to make sure I understand what the DA considers, this group of DAs considers the appropriate response for them to this crisis.
Well, yeah, what we have is, we have had ongoing discussions with the local defense bar about relief of people as a result of concerns of the virus concerns within the prison. And I suggest it's not, excuse me?
I'm just trying to figure out what you're doing and what you think is acceptable for you to do, because I'd like to understand what it is that you're doing, because if we order you to do just what you like to do, I take it there's no problem, but I'm trying to understand what it is you're doing differently in response to the crisis.
Yeah, but we're facilitating the expedited review of these motions. And we are, if motions are coming in, and if there's something that we can agree to, we will do it. I don't know that it's necessarily that much different, but there's probably more volume, and it's a more a more specific motion. But it's following a similar practice to the regular bail relief practice, but it's being addressed daily and immediately. Because the concern is immediacy. And my only question, it's not that the DAs don't recognize that there's a potential for a big problem in the corrections facilities. But right now, on the record that's before this court, whatever the problem is, it seems to be under control within the prison system, more so certainly than it is outside the prison system. So whatever they're doing with as far as, controlling people who are coming in, the hygiene, it seems, at least from what we know now, seems to be working. That can change. And that's where we have the civil defense.
Right. So you want us to stay out of this because it's fine where it is.
I think you should stay out, yes.
I just want to make sure I'm encapsulating your views, which is that you don't want us to do anything right now, right?
Your Honor, I believe that's our opinion, that right now, as things stand, and as your trial courts have reported to you, the system is working. It's addressing the issues that are being raised in a timely manner, and it is working. Now, at some point, there may be something, but there are limits, I suggest, to what the judiciary can, in fact, do. And this is not a one-branch government problem that we can order people to, see out of their lane and do certain things to fix. This is an emergency that affects the entire state, and it's the governor, I suggest, that controls now.
So the pretrial issues are really more our responsibility than his, aren't they?
Yes, I totally agree with that. But I would just suggest that they are being handled very well. There is a process in place. You can always move, at least in our experience, for a review of bail based on a change of conditions. Most of the time, we see that bail is imposed or whatever without prejudice, meaning that people can come back at any time. That's the routine, even apart from this virus. But I think what's changed is how it's conducted and how we have to open up the courts to a certain extent, or at least make the judges available so that these emergency motions can be heard. And in our experience, they are being heard, and they're not aware. I'm not aware of any complaints presented that like the trial judges have said, that there's been a complaint about inability to access the courts in order to present a motion for relief.
That's all I have.
I've got a few questions following up on Justice Kafker's questions. You accept, I gather, at least your DAs accept, that the pandemic constitutes a change in circumstances which is appropriately considered in terms of revisiting bail.
Yes,
wrong?
we would not object to that.
Okay, and what do you consider to be the practical consequence of the change in circumstances with regard to the revisiting of the issue of bail?
Well, I mean, it's the whole. It's an individual. I think it's got to be an individualized inquiry. If it's all about that my health is in danger, I think we need to be presented with some sort of evidence or what the facts are about your health, what the particular danger is. I think it's been very helpful from the department to get the information from the Department of Corrections as to what's being done within there to prevent, control the spread of the virus. I think that's important to anybody. Yes, and what the sheriffs are also doing, both the Department of Corrections and the sheriffs, they're following everything the CDC says to say, whatever the proper protocols. It seems to be working. That kind of information is relevant to anyone, to either the judge who's making a bail determination or considering whether or not to release a person to bail. Just like where will the person be released to? That's important. So there are factors that have to be considered. And if someone can be safe, if a pretrial detainee can be safely released into the community, in appropriate cases, the district attorneys would agree to that, I suggest.
Is it your view that there's a change in circumstances only when somebody tests positive within a jail and there's a concern that the jail is going to become a cluster?
Not necessarily, Your Honor, but I think there has to be some sort of correlation between the request for relief and what's going on in the jail. If there's and how the release will actually alleviate that and be necessary.
I guess my last question focuses on the, are your DAs opposed to a process in which they identify a number of individuals who the defense wishes to consider, and you confer with defense counsel and with probation and the sheriffs and attempt to identify which cases you can agree upon are appropriate for release and which you're going to be adverse with respect to?
Well, Your Honor, I think what our main objection is that we, the DA's office, are going to be ordered to compile that list. I suggest that is an onerous burden. We don't have that information at our fingertips. Excuse me. But if a list is prepared to us, presented to us, we would certainly do whatever we could to pull the files, review those files, and make any input that we could as quickly as we possibly could. But it's more, the question is, how are we going to do this? And get the information from either the jail or the is personal to a particular defendant, I would suggest, in these particular circumstances. And particularly where the defendant or the inmate or the pretrial detainee would be represented by counsel. It just seems much more efficient and makes much more common sense if the defendants, through their counsel, or even not through their counsel, file a motion. I mean, there might be some things you can do to put in the jails, in the houses of correction, what to do to file a motion, like was, I believe, was suggested by the representative of the trial court, some sort of form motion. It doesn't have to be a treatise. I mean, we just need to raise the issue. But it just doesn't make sense to put the onus on the district attorney to compile all that information where there are other parties.
Is your concern the gathering of information, or is your concern an obligation to be conferring and attempting to identify, in terms of triaging these individuals, which individuals you agree are appropriate for release and which are not? I'm trying to figure out what your position is on that. Are you opposed to a process to attempt to work with defense counsel and attempt to identify those individuals who should be triaged for release?
No, we're not opposed to a process, but it would be nice if the counsel brought a motion, brought whatever needed to be brought to our attention, so we could act on it. I think the process of having us devote staff, and we are at skeleton staff, maybe go into courthouses or try to go into courthouses that are closed. I mean, that creates problems for our staff too, and it would create delay. So if whatever party has access to the information that's essential to bringing the motion should bring it, and if they can do a list, that's fine.
Okay,
if that makes sense.
Justice Gov.
And bring the list to us.
No further questions, Chief.
Justice Lilly?
I just want to make sure, thank you, Chief, that I understand one thing, Ms. Sullivan. So, do you agree that even if somebody hasn't tested positive, even if there hasn't been an outbreak yet in a particular facility, that the COVID-19 pandemic can be considered as it relates to a reconsideration of bail because of reasons of social distancing and possible contagion?
Yes, it's certainly on an individualized basis, sure.
Okay. I have nothing further.
Justice Budd.
I have nothing, thank you.
Justice Cipher.
Nothing, thank you.
And Justice Kafker.
One follow-up. You raised the concern about your staff going into the offices. So in order to do this process, your view is if we did what the special master recommended, we're going to be bringing in large numbers of your people into the office who are now working remotely. Is that correct?
Yes, we do. We have many people trying to work remotely. I mean, we do have a skeleton staff in our offices, but some of the staff in our courthouses have been precluded from going into there because they have been closed. So yes, and in fact, other staff in other DA's offices too have found that problem. And yes, I think it would take bodies to track down that information.
Thank you. That's all I have.
And I have no further questions. Thank you, Ms. Sullivan.
Thank you.
And Mr. Hernandez, you are our last person
Good
to argue.
afternoon, Judge. Thank you very much.
Good afternoon, Mr. Hernandez. You may proceed.
If it please the court, my name is Robert Hernandez, and I'm here representing the 14 elected sheriffs of the Commonwealth of Massachusetts. These elected sheriffs have a constitutional and statutory obligation for the care and custody and well-being of inmates, as well as a responsibility of public safety for the communities they serve. In this request, petitioner alleges that all of these individuals have a violation of their Eighth Amendment right and could be considered cruel and unusual treatment. But also, it could be considered deliberate indifference on behalf of the sheriffs. This court has heard no evidence of such. Petitioner, prior to filing this petition, has failed to look at the actions, the work, the procedure, and the policies the sheriffs have put forward so that the facilities can safely house the individuals in question. This is demonstrated through the affidavit submitted by each sheriff. These actions by the sheriffs were in place prior to the CDC sending out the guidelines for correctional facilities. In fact, guidelines were sent out just 7 days ago, and these policies were put in by all the sheriffs, I'd say, in the beginning of March. The sheriffs have already contacted and are constantly in communication with the CDC, Department of Public Health, and MEMA. The sheriffs have taken and will continue to take action to safeguard the safety of their inmates and their employees. To state that it's a violation of an individual's Eighth Amendment right and cruel and unusual is equivalent to saying the sheriff has shown deliberate indifference, which is the farthest from the truth. The sheriffs were one of the first ones to make sure their employees and their inmates were safe. They did this and continually do this on a daily basis in a number of ways, including but not limited to, they have stopped on all non-attorney visits and afforded more time on phones for family contact. They have developed an enhanced screening procedure to help screen for symptoms of COVID-19 for any new inmate coming into the facility. They did this by having a screening of all employees also coming into the facility. They did this by making sure the insides of the facility are continuously sterilized and cleaned, opposite of what the petitioner asserts that it's a Petri dish. They did this by making sure that all individuals are provided hygiene products, which include soap and sanitizer, despite the petitioner's allegation that they're not given any soap. They do this by educating and constantly educating both inmates and employees of the need to keep washing their hands and hygiene issues. There is a continued education of COVID-19 for both inmates and employees. If there is an inmate that may test positive, they arrange for the inmate to be isolated and contained and away from the other inmates in many different ways. Some jails have set up different units specifically for this. It should be noted that COVID-19 is new. The sheriffs throughout history have had to deal with issues in the past, some examples being SARS, Ebola, MERS. And in dealing with these examples, they were able to provide a safe facility for the individuals. Further, petitioners' request for relief as categorized, I believe, is reckless. It will cause more harm to individuals that they allegedly want to help. Sheriffs have the task and have worked hard with their responsibility and commitment to reintegration. They've worked hard based on the sheriff's commitment to safety for the community and individual. You have to look at these inmates and these people in jail right now. But currently, the majority of inmates suffer from medical, psychological, and substance abuse disorder. They, in fact, are the vulnerable ones, and maybe for the first time, they're receiving treatment. Maybe for the first time, they're receiving counseling. Maybe for the first time, they're dealing with the substance abuse disorder. That's going to be taken away. That's a hard stop. We're asking for individuals to be released as the petitioner wants in a category that endangers them, a category that doesn't address individual issues each person has. If the court allows this action and categorizes inmates by age, by how much time they have served, you're not taking into consideration each individual person as their needs. When the petitioner argues that they're going to be vulnerable outside, they are vulnerable before they got to jail. Some of them, for the very first time, are receiving medical treatment. Some of them, for the very first time, are being able to address their opiate addiction. You're taking that away from them by doing a hard stop. Also, the homeless issue. we have been in contact with a number of shelters. They are overloaded. They don't have places. And as a medical field will tell you, shelters themselves that the petitioner wants to help put them in right now have COVID-19 issues. These individuals are safer there than they would be in a shelter. These individuals are being taken care of, and they're in a much cleaner, safer place than what the petitioner wants. For the court to rule that there is a violation, the court's saying that the sheriffs have now a deliberate indifference. And I would submit to you, if the court enters any order, I would respectfully request that the order indicate that this is not a result of deliberate indifference on behalf of the sheriffs. I'm available for any questions.
Okay, before we ask, I just want to, before we go where we don't need to go, I'm referring to page 19 of the petitioner's reply brief, I read paragraph 1. Both the opposing DAs and the sheriff seek to refute constitutional claims that, in fact, petitioners have not yet brought. Petitioners have contended that the risk posed by COVID-19 to incarcerated persons implicate constitutional guarantees for substantive due process and against cruel and unusual punishment. But as the trial court, the Department of Correction, and other respondents point out, petitioners offer that contention merely to establish that COVID-19 outbreaks carry potential constitutional ramifications, not because we seek a ruling on these issues at this time. So, to my knowledge, the petitioners are not raising a constitutional claim, and if that is incorrect, I would invite one of the petitioners who are on the telephone call to correct that. But to my knowledge, they are not bringing constitutional claims. And not having heard any refutation of that, I'll then turn to Justice Gaziano.
Right. Mr. Harnett, just one question for me. As far as the compiling of these lists and the like, can you give me some idea of what it takes to do this and how easy or hard it is to go through your I guess it was called census in one of the briefs, as far as who's in your facility and who's being detained pre-trial and bail that they can't afford?
Well, the sheriffs have a daily reporting of who's being held, who's sentenced, and who is being held on bail. That could be accumulated very quickly. I will say on that note that since March 10th, all the sheriffs combined have released 1,441 inmates.
Can you give me that figure again?
1,441 inmates.
And is that an unusually high number, or how does that relate to?
The sheriffs have been working with most of the district attorneys as far as helping provide them the information as to what the conditions are of the inmates as far as health-wise, being able to go to a home, having a place to go to, whether they're in medical treatment. There are some inmates right now, as we speak, that are receiving daily diabetic medicine, which they weren't receiving before. There were some receiving chemotherapy, which they weren't receiving before. That's a concerning factor the sheriffs have.
And Mr. Hernandez, as far as the ability to manipulate the data as far as giving reports, how hard or difficult is it to give a list if it was offense specific, if you had to take out charges, put in charges, to be able to spit those reports out?
That would take a good amount of work. We break down the numbers as to pretrial and non-pretrial.
Okay. All right. Thank you, Mr. Hernandez. No further questions.
Justice Louis.
I am all set. Thank you.
Justice Bush.
Good afternoon, Attorney Harnez. I've got a quick question for you. I understand that your point is that the sheriffs are taking good care of the inmates. But do they have, are they opposed to the release of low-risk, nonviolent pretrial detainees who can't make bail, for example?
I wouldn't say they're opposed to anything with regards to make sure that there's a balancing test of safety for the inmate as well as the community. If there is, I'm going to say, low-hanging fruit where you're saying this person could be released, that's fine, but if the person right now is in the match program on Suboxone for the opiate addiction, well, let them loose without any guidelines, without any counsel, without it go through the reentry process, is probably going to have them pick up. And then we just had a case just out of Boswell. The person was released a week ago under this premise, and he's already been arrested. He's being arraigned today. If the purpose is to help these individuals, the sheriff's all in unison. They want to do that. They just want it done responsibly so that we don't categorize by age. One jail has a 60-year-old individual that right now is being treated at Lemieux Shattuck. Under the category of 60 years old, that person should be released. Where's he going to get the treatment? You can't even contact Mass Health now, so we'll let them go without insurance and without support systems around them. We have to consider that for the safety of the individuals.
Thank you.
Justice Pfeiffer.
Thank you, Chief. I have no questions. Thank you.
Justice Kafker?
No, my only comment, Mr. Hernandez, is I agree. I saw no signs of deliberate indifference there, and I think that point is well worth making. Because it's not crystal clear exactly how we're going to be dealing with incarcerated people if there isn't a constitutional violation. So I'm not sure how we would do so. Is that also your view, that unless there's a constitutional violation, we lack authority to deal with the incarcerated as opposed to the pretrial detainees?
And that's the fear the sheriffs have. I believe that's the only mechanism to get in there. And the sheriffs are mainly concerned that in order to get in there, you're going to have to find the deliberate indifference on behalf of the sheriffs.
Thank you. I have no further questions.
Okay. Just to be clear, you're not contending that we need to find deliberate indifference to act with regards to those who are being held pretrial, correct?
No.
Okay. Are there any positives in any of the jails right now? Any detainees or inmates or prison personnel jail personnel who've tested positive? I thought I heard something about Middlesex.
Yes, presently as we speak, there are two, and there's one employee in another facility.
So
there were two inmates and one employee in another facility. In both cases, the employee is at home right now being treated, and the two inmates, they are being held in place safeguards their health and also as well as the inmates around them.
Okay. So I understand that you're appropriately concerned for the health of your inmates and of course of your staff as well as the public. What would you, but recognize that we're going to be getting a substantial number of these motions, and I think you also recognize that the sheriffs have information which may be relevant to that. You've described circumstances in which there would be information which a judge perhaps should know as to whether the person is on MAT or other types of circumstances. What would you suggest to be a process which would allow us most expeditiously to be able to resolve a substantial number of motions in a very short time under very challenging circumstances where it's being done virtually as opposed to in person?
Judge, I have a couple of concerns with that. I think to lump them all in would be difficult. Also, I'm concerned going down the road of saying because someone has a medical condition, we shouldn't consider them for release because they're being treated. I worry about going down that road. I worry that at one point somebody that's in the match program, they won't have the support system we hold because of their match program. We should for their own benefit, and we should because it's the right thing to do, but I wonder about people making that argument in court, how it's going to impact decisions down the road. I know the sheriffs are more than happy to work with as long as it's individualized and we look in each individual's concern. The petitioner should be with us on that because they have indicated their concern are these individuals. And it's not just a matter of getting them out of jail. It's make sure that they're out there and living their lives. They are human beings, and we're concerned about them. And we have to make sure they get all the support system they need. It is a bad time right now to cut people loose and say, hey, there you go. by the way, nobody's really coming out to help you right now because everybody's bunkered down. It's a very dangerous thing, very dangerous road we're going down.
So again, I'm just trying to understand, is the sheriff's position that the pandemic is not a changed circumstances which would warrant revisiting a person's bail, or is it that there's a right way to do it and a wrong way to do it?
It's a little bit of both. The sheriffs historically have dealt with not this type of situation, but other situations like Mayor's SARS. They've dealt with contagious issues out there within the facilities, and they kept the facilities safe. Then on the other argument, if we're going to do it, let's do it the right way. Let's do it individual. Let's look at what the person needs, help them, and also the community around them.
Okay, and help me to understand what the sheriffs would contend would be the right way, recognizing that the sheriffs do have information about people in their facility, which may be a benefit either to the DA or to the defense counsel or certainly to the judge. What is the right way to do it?
I think the sheriffs being at the table to be able to provide the information of what sort of treatment, where the individuals are with regards to their medical issues, to their substance disorder issues, and to the psychological issues. I think we need to be at the table. These sheriffs live with these inmates 24 hours a day. We probably know them more than their own attorneys know them.
And what process would you put in place, given how difficult it is to get everybody to the table these days? What process would you put in place to allow that to happen?
I can only say information share, and I don't have a mechanism in my mind as how to get it done, but I just know the tools that we need to make sure that it gets done. I don't know what the mechanism is, but we should all have an input in this for these individuals themselves.
And in response to a question from Justice Gaziano as to what information is readily available to the sheriffs, I gather with regard to an imaginary John Smith, you would know what programs John Smith is in, and you probably would know a little bit about that person's medical risks and what that person is facing. Would you also know what he's been charged with? I'm trying to get a sense as to what information
we would know what he's charged with to an individual. We would know if he's in match treatment, taking Suboxone. We would know if he's any medical conditions. We have people with diabetes and other medical conditions. We could update and keep that inform the court of that. We could also know, tell you about, explain to you where they are psychologically wise. We will provide that information, and I think every sheriff will tell you they're more than happy to.
I have no further questions. Justice Gaziano, any further questions you may have?
No, thank you, Chief.
Justice Lowy?
All set, Chief.
Justice Budd?
No, thank you.
Justice Seifer?
No, thank you.
Justice Kafker?
All set, thank you.
All right, I have no further questions. So, after a mere
4 hours and 35 minutes.
We have concluded this hearing. I am well aware that we have the case of Commonwealth versus Christie that we need to hear, but in view of the hour, what I will suggest is that we take a half-hour break, and I think it makes sense for people to hang up, and I will commence a conference call. I think it's going to be a much smaller number.
Now exiting.
So at 2:50, we'll plan to reconvene, and at that time, we'll hear with regard to the attorneys in the case of Christie versus Commonwealth. I thank you all for your arguments. I thank you all for your forbearance. We, of course, will take the matter under advisement, and we shall be back to hear the case of Commonwealth versus Christie at 2:50. Thank you all.